All rise. District Court's again in session.
All right, if we could please have the jurors brought in.
All right, please. Here's our President County for your honor.
All right, thank you. Mr. Bailiff, please be seated. All right, good morning. We're back on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. We're continuing evidence in the state's case in chief. We left off yesterday with Detective Kaya Kamanu on the stand in direct examination. I believe the state's still proceeding with more direct. Is that correct?
That is correct, Your Honor.
Okay, if you'd like to continue with testimony, Detective Kaya Kamanu is here. You can go ahead and take the stand and we'll allow you to continue on direct. I will note also, I received all of the juror affirmations and the jury is all here properly seated. So thank you again, ladies and gentlemen of the jury, for continuing to follow the court's instructions as you retire home each night. And with that, Ms. Blake, once you're ready, you can continue with your direct.
Your Honor, may I be handed back State's Exhibit 107B?
Yes.
Detective Kaikamanu, when we left off yesterday, we had been talking about some searches linked to a Homer J. Maximus account. Do you recall that?
Yes,
And you had prepared an exhibit summarizing some of the searches that you located on that account. Is that correct?
yes,
Your Honor, I believe we left off with the state having asked permission to publish State's 107B.
Yeah, we had the tech issue. I believe and hope that's all been sorted out. They worked on it for a while, so I think we've got things working. If those monitors don't work also, please make an indication, jurors, and you can publish.
Thank you, Your Honor. If I may have just a moment, let's see if I can get this fixed. Thank you for your patience, everyone. Sorry about that. Detective Kaikamanu, does this look like the start of the PowerPoint presentation that you created?
Yes.
And can you remind the jury, who was that Homer J. Maximus account ultimately associated with?
Alex Cox.
And if we turn to the first slide, can you see the date on there?
Yes.
And what date is that?
October 8th, 2019.
And can you remind the jurors when the attempted shooting of Tammy Daybell occurred?
October 9th, 2019.
What is it about these searches on October 8th that caught your attention?
These searches, Alex Googled the 100-yard drop to 200 and 100 to 300.
And when we talk about a drop, can you explain what that is?
During shooting and sighting in your rifle with your scope, depending on how far you're out in yardage, a lot of times you will dial in that scope to a precise point of impact of your bullet. The drop of the bullet, the further you're out, the drop of the bullet tends to go down a little bit.
So essentially the idea being that from where you're standing, that's going to be where the bullet will go and where it will ultimately land or hit a target.
Correct.
And also in there, it looks like it was a 6.5 Grendel specifically.
Yes.
What kind of gun was recovered from an apartment associated with Alex Cox?
Alexander Arms 6.5 Grendel.
And then it looks like there's another date on there, October 9th of 2019. Is that correct?
Correct.
And there's some additional searches there. What about those caught your attention?
He searches just different uppers for ARs, muzzle energy brake of a 6.5 Grendel, and sizing of frog tog pants.
And breaking those down a little bit and actually going back to October 8th, was there anything else other than it being the 6.5 Grendel that stood out to you with these particular searches?
Not at this time to me, no.
And then on the October 9th, we've talked about the 6.5 Grendel. What about the frog tog sizing caught your attention?
There were some frog togs purchased on this same day at a different location.
And from your investigation, did you learn anything in relation to where those frog togs may have been purchased?
Yes.
And where was that?
Sportsman's Warehouse in Idaho Falls, Idaho.
Did you learn anything in relation or review anything in relation to where a device associated with Alex Cox was located that same day?
Yes.
And where was that?
Sportsman's Warehouse in Idaho Falls, Idaho.
Do you know what color those frog tog pants were?
Black.
And then when we go to the next slide, can you read the date of these searches into the record?
October 10th, 2019.
And can you explain what about these searches stood out to you?
On this day was after the attempted shooting on Tamara Daybell. And the next day, he is searching if an AR functions in cold weather, how an AR functions in cold weather. Hornady one shot shooting in cold weather. Also had a prep your AR to shoot in cold weather. He also is searching if mag rings shrink in cold weather.
Do you reside around the Fremont County area?
I do.
Have you resided there for some time?
Yes.
What are Octobers generally like in that part of the state?
Microphone, please, Mr. Pryor.
Objection, Judge. It's calling for speculation. He's talking in generalities, and he has no testimony and knowledge of what the weather was like at any time this particular year.
Your Honor, he testified that he lives in the area and has lived there for some time. I think it would be
I
within his
agree, and
personal knowledge.
All overruled.
Thank you. If you can answer.
Can you repeat that?
What are the Octobers generally like in that part of the state?
Octobers get fairly cold in that month. Sometimes prior to that month, Octobers in eastern Idaho are hit and miss.
Do you know what the temperature was on that day?
Believe it was 26 degrees.
Judge, I'd like some foundation as to how he knew that.
Ms. Blake, knowing the precise, I agree, degree temperature would require additional foundation.
Did you do anything to look into what the temperature was that day?
I did.
What did you do?
I Googled and got on to the National Weather Service and put in that date, October 9th, 2019, to see what the temperatures were during that day.
And what were the temperatures?
26 degrees.
And if we go to the next slide, can you read the date of these searches into the record?
October 12th, 2019.
What about these particular searches caught your attention?
So this was after the attempted shooting on October 9th. On this search, he is Googling how to attach a ghillie suit, a cover to a ghillie suit. He's also Googling if a 6.5 Grendel will shoot through a windshield. He Googles the penetration through Dodge Dakota, 2008 Dodge Dakota steel body thickness, the thickness on the doors of a 2008 Dodge Dakota, and the gauge thickness of, or how thick 22 gauge steel is.
And if we break these down a little bit, can you explain what a ghillie suit is?
A ghillie suit's used a lot in the military, snipers. It's a cover that they can use for cover while in the weeds, the brush, the trees, so they're not seen.
And what about a 2008 Dodge Dakota stood out?
Tammy Daybell and Chad Daybell had a 2004 Dodge Dakota registered to them.
And again, a 6.5 Grendel was recovered from an apartment associated with Alex Cox.
Correct.
As part of your investigation, did you also look at some shooting range records?
I did.
Do you recall which shooting range you reviewed records from?
It was a sportsman's club located in St. Anthony, Idaho.
And Your Honor, I have what's been marked as States Exhibit 396 and 396A. Your Honor, I just handed the bailiff a courtesy copy for defense counsel, a copy for the court, and a courtesy copy for Your Honor.
All right.
And Detective Kaikamano, if you just look through those particularly Exhibit 396A. And Your Honor, while he's looking through those, I believe these are stipulated to exhibit. The first Exhibit 396 would be the affidavit of business records, and Exhibit 396A would be the actual logs.
That is correct, Judge.
All right. Those have been offered now and admitted. So 396 and 396A are both admitted exhibits.
Thank you, Your Honor.
Okay.
And Detective, do those appear to be the records that you reviewed?
Yes.
Were you able to determine whether or not it appeared Alex Cox had been at that gun range?
Yes.
And what did you determine?
Alex Cox didn't sign in as Alex Cox on these sheets. He did sign in as C. Quint, which C. Quint, or I should say C.P. Quint, is the license plate on his Ford F-150 truck. So on the sign-on sheet, the only letter that's missing in that is the P.
And were you able to determine how many times this C. Quint or Alex Cox had visited that gun range?
Yes.
How many times had he visited?
5 times through October 7th to the 15th of 2019.
And again, the attempted shooting of Tammy Daybell was which day?
October 9th, 2019.
And what day was Tammy Daybell pronounced dead?
October 19th, 2019.
As part of your investigation, did you also review some data recovered from a phone associated with Tammy Daybell?
I did.
And Your Honor, I have what's been marked as States Exhibit 108. It is a affidavit of business records in relation to Tammy Daybell's phone.
Thank you.
Give us a moment, Ms. Blake. We're gonna verify the number here. I think we've already got 108 admitted.
Your Honor, may we approach briefly?
Yes, actually, let me have the bailiff hand you the admitted exhibit for your review. Yeah.
All right, Your Honor, I think we have sorted that out. So State's Exhibit 108 was already admitted.
Yes.
The state would ask to have the witness shown State's Exhibit 291. Do you recall reviewing that particular email?
Yes, I do.
And Your Honor, there is a stipulation to admit the contents of Tammy Daybell's phone. This is one of the items retrieved from her phone. So the state would move for admission of Exhibit 291.
Any objection?
No, Judge.
All right, Exhibit 291 is admitted.
And Your Honor, the state would ask for permission to publish.
You can publish.
And Detective, are you able to see who sent this email?
Yes.
And who was that?
Tammy Daybell from tammy.daybell@gmail.com.
And are you able to see who it was sent to?
Yes.
And who is that?
Mark Daybell at mark.daybell@missionary.org.
And can you see the date that this shows it as having been sent?
Yes. On 10/13/2019 at 2:38, or correction, 2:23:18.
And Your Honor, I'm going to pause to allow the jurors to read.
Okay, thank you.
And Detective, this was sent just 4 days after that attempted shooting, is that correct?
Correct.
And when we look at that second paragraph, are you able to see approximately what time Tammy says she arrived home that night?
Yes, approximately 9:15.
And are you able to see in there, actually, let me back up. Can you read the last couple sentences there, starting with "I looked up"?
I looked up thinking it was Dad or Garth to help me carry stuff in. Nope, it was a guy dressed all in black with a ski mask on, pointing a rifle at me.
And Your Honor, again, I'm going to pause to allow the jurors to read. And Detective Kaikamanu, could you read the paragraph starting with, "I think I was," that first full paragraph into the record?
I think I was a bit in shock because I just said, "What do you think you were doing?" Then I noticed the rifle was actually a paintball gun. It had a hopper on top. The guy started pulling the trigger, and I could hear the clicking and whooshing sound of an empty paintball gun. He stayed standing by the back of the car, just pulling the trigger while pointing the gun at me. For some reason, I just kept asking him what he thought he was doing. At that point, I was actually more annoyed than scared because he was standing between me and the door and he didn't step towards me or even say anything. The scared part came after when my brain thought of things that could have happened.
And Your Honor, again, I'm going to pause to allow the jurors to read.
All right.
And Detective Kaikamanu, could you read the last sentence of that second paragraph starting with "on Thursday night"?
On Thursday night, though, I didn't go to Zumba because I was quite understandably did not want to be out after dark alone.
I'm going to go back to that paragraph that we were looking at previously. In there, Tammy refers to the paintball gun as a rifle. Is that correct?
Correct.
And she specifically references a hopper.
Yes.
And that's in reference to why she thought it was maybe a paintball gun.
Yes.
She also indicates the guy started pulling the trigger. Is that correct?
Yes.
In this, do you see where she indicates that she was scared?
Yes.
And in that last sentence that we just talked about, she indicated she was scared to go out alone the next night.
Yes.
Your Honor, I'm going to ask to publish State's Exhibit 281A. It was admitted yesterday.
Okay, you can publish.
Detective, we talked about this firearm yesterday. Do you recall that?
Yes.
And where was this recovered from?
This was recovered from Alex Cox's apartment.
And can you remind the jurors what type of firearm this is?
This is an Alexander Arms 6.5 Grendel.
And I think you have a pointer up there. But when we just looked at that email from Tammy, she specifically references a hopper or what she thought might be a hopper on the firearm. Can you again explain where on this firearm, if this were a paintball gun, where the hopper would be located?
Again, like I was referencing yesterday, the scope is on the top of the rail of the gun right here. On a paintball gun, it comes off right on the side and up right there.
So the hopper would be around the same location as this scope.
Yes.
We saw some searches about drilling a baffle to make a suppressor. Can you talk a little bit about what a suppressor is?
A suppressor is a device that can be screwed onto the end of rifles, handguns, miniguns that will make the bullet coming out quiet. Sometimes people make homemade suppressors, which they have to drill holes. And you can also buy those legally.
Where on the firearm would you attach the suppressor?
The suppressor is attached right on the end of the barrel right there.
And Your Honor, I have what's been marked as State's Exhibit 281C, if I can have the detective shown a copy.
You may.
Detective, do you recognize that photo?
Yes.
And did you in fact take that photo?
Yes.
And what is it a photo of?
This is a photo of the end of the rifle.
A close-up photo?
Yes.
Your Honor, the state would move for admission of State's Exhibit 281C.
Any objection?
No, Judge.
Exhibit 281C is admitted.
Your Honor, may I have permission to publish?
Yes.
And officer or detective, can you tell us what we're seeing on the end of that gun?
So at the end of the rifle right there, it's threaded. A lot of times there's muzzle brakes on there, or you can take that muzzle brake off and thread a suppressor onto that.
Detective Kaikamanu, through your investigation, did you learn anything in relation to whether or not Alex Cox was in the area of the Daybell residence on October 9th?
Yes.
And what did you learn?
A device associated with Homer J. Maximus.
Judge, foundation.
It's like,
Thank you, Your Honor. Detective Kaikamanu, as part of your investigation, did you review reports of other investigators?
Yes.
And did you discuss the matter with other investigators?
Yes.
And through your discussion and review, did you learn anything or review anything in relation to the location of a device associated with Alex Cox on October 9th of 2019?
Yes.
Did you learn anything in relation to a device being in the area of the Daybell residence?
Yes.
What did you learn?
On October 9th, 2019, a device that was associated with Alex Cox, known as Homer J. Maximus, was located going up and turning next to the Daybell residence and driving and making a turn and going back around the Daybell residence. This time frame was about 4:55 p.m. to 5:03 p.m.
So 4 hours or so before the attempted shooting.
Yes.
And later in the day, that same device was at Sportsman's Warehouse in Idaho Falls. Is that correct?
Yes.
Detective Kaikamanu, are you aware if any paintball guns were located in the residence associated with Alex Cox?
Not that I'm aware of.
Are you aware if there were any other calls on October 9th that you found in relation to anyone else reporting a masked man pointing a rifle at them?
I did not find any.
You aware of any other reports around that time about a masked man pointing a paintball gun at anyone?
No.
So to the best of your knowledge, this was an isolated incident around this time?
Yes.
Do you recall reviewing anything in relation to some geofence location data?
Yes.
What dates did you review that in relation to?
I got those geofence warrants through October 18th into October 19th, 2019.
And again, what day was Tammy pronounced deceased?
October 19th, 2019.
Did you end up receiving responsive data in relation to the geofence?
I did.
Which specific locations did you ask for that data for October 18th to October 19th?
I did two fences, one located at 202 North, 1900 East, which is Chad and Tammy Daybell's residence. And then I did another one at 3462 Salem Highway, which is the LDS Church, just 2.6 miles south of the Daybell residence.
And with those geofence warrants, were you looking for a specific perimeter radius on those?
Yes, I did 150 meters.
And can you tell us a little bit about what data you initially got back in your request to those?
So when I requested information for data on any device coming through those through the geofences, I got a response from Google with a bunch of Google identification numbers.
What did you then do with those identification numbers? Can you talk us through that process?
Yeah. So when we write a warrant like that, Google will send back the numbers that have been going through through the geofences. They don't come back with any names. And so we then had to write another warrant with those numbers to try and find out the associated name to those devices or those numbers.
Did you locate some specific numbers that you did something with.
I did.
How many numbers caught your attention in that initial response?
So the time I had the geofence warrants up, there were 4 numbers that had gone through both geofence warrants or locations.
Did you do anything to follow up on those 4 numbers?
I did.
What did you do?
I met with Detective Stubbs, who at the time worked with Rexburg PD, and he has knowledge on how the geofence works. And we went through the numbers. 2 of the numbers.
Judge, I'm going to object at this point. There hasn't been sufficient foundation to where this knowledge has come from. I've been somewhat patient.
Sustained.
Detective Kaikamanu, did you send in a second search warrant in relation to these geofence?
Yes.
And did you receive responsive information?
Yes.
And how many numbers did you request additional information for?
4.
And you were talking about having met with Detective Stubbs. Did Detective Stubbs initially recognize anything about those 4 numbers?
Judge, objection. That would call for hearsay.
Sustained.
Your Honor, if I may respond.
Well, I would re-ask. I think it was just going to elicit hearsay.
Did you learn anything in relation to those 4 numbers prior to getting the second return?
I did. Yes.
And what did you learn?
Judge, again, it may call for hearsay.
Your Honor, this goes for why the officer did what he did next in his investigation, not for the truth of the matter.
Overruled. You can answer.
I learned that one of the numbers that had come back in my geofence warrant, Detective Stubbs already had that number, which was associated with Alex Cox on a different warrant that Detective Stubbs had wrote and got information back.
And in relation to the other 3 numbers, did you end up receiving responsive data on who those devices were associated with?
I did.
Did you do follow-up on that?
I got a hold of 2 of them. One of them I could not get a hold of.
What were you able to determine in relation to those other 3 numbers?
One of them lives in the Parker area, which is north of Chad Daybell's residence. And the other one lives on Trapper Lane, which is also north of the Daybell residence.
So would it have been normal for their devices to be in that area?
Yes.
In relation to the device associated with Alex Cox, what did you learn regarding that device?
The device that was associated with Alex Cox and Homer J. Maximus, and looking through the data, the night of October 18th, 2019, that device was at the Salem Church at 10:04 that night, or 10:05 p.m.
Sometime just after 10?
Correct.
Do you know how long the device showed as being located in that vicinity?
In correctional time, I believe it was 10:07 p.m. and it showed him there until 10:45 p.m.
And when we're talking about a geofence warrant, do you know what type of data they're looking at as far as placing a device there?
I believe that is off Wi-Fi and GPS.
So with the geofence, it's located there until 10:45 p.m. of October 18th, correct?
Correct.
Did you learn anything else in relation to that device as far as any later time that night?
That device shuts off or goes dormant and is no longer there. And it is later picked up at 11:53, roughly 7 miles south of the church.
Judge, could we identify what church he's talking about?
And is this the same church that you previously referenced?
Correct, the Salem Church.
And again, how far is the Salem Church from the Daybell residence?
2.6 miles.
So we know a device associated with Alex Cox is there from 10:07 to 10:45 p.m. Is that correct?
Correct.
And from there, we're not sure where the device is
Correct.
until 11:53 p.m.
Correct.
And at 11:53 PM, can you remind us again where that's located?
It was located about 7 miles south of the Salem Church on Highway 20.
Through your investigation, did you learn who the last person besides Chad Daybell to see Tammy would have been?
Garth Daybell.
And through your investigation, did you learn where Garth Daybell was on the night of October 18th of 2019? October 18th of 2019.
He was at work.
Through your investigation, did you learn if he was at work all night?
I believe he got off around 1 o'clock in the morning.
Do you know where he was working?
He worked at that time, he was working at the Haunted Mill.
And what is the Haunted Mill?
It's October. The Haunted Mill is a haunted, scary attraction.
And it's seasonal.
Seasonal, yes.
When you looked at that geofence, did you get any return on a device associated with Chad Daybell?
No,
Not at either location.
no.
Did you later learn where Chad had indicated he was on October 18th into the morning hours of October 19th?
From other deputies' reports, he had told them that he had been home.
And yet no device was located in relation to Chad Daybell.
Correct.
So in your review, there's location data placing a device associated with Alex Cox near the Daybell residence on October 9th of 2019, correct?
Yes,
And on the night of October 18th of 2019?
yes.
Were you able to find any connection between Alex Cox and Tammy Daybell?
No,
Were you able to determine who Alex Cox knew in that area?
at that time, no. The only person that I was aware of would be Chad Daybell.
Through your investigation, did you become aware of some emails from Charles Vallow that he'd sent to an email that he sent to Tammy Daybell?
Yes,
Did you also become aware of an email Charles Vallow sent to Chad Daybell?
yes.
Do you recall what the content or what the gist of the email that he sent to Tammy was about?
The email that was sent to Tammy was on June 29th, 2019. And Charles was reaching out to her school address, email address, and telling her that he had some information about an affair going on. He didn't go into too much detail because he didn't want to explain all that over email, and left Tammy his number to have Tammy call him.
And through your investigation, were you ever able to determine whether or not Tammy Daybell had contact with Charles Vallow?
I was not able to confirm that.
And in relation to the email Charles sent to Chad Daybell, do you recall the gist or content of that?
Yes.
And what was that about?
So Charles sent on the same day an email to Chad, telling Chad that he was aware of what was going on between him and his wife, and Chad needed to tell his wife, or Charles was going to expose them. He was also aware that Lori had sent him some dance videos of her, and that was inappropriate.
Through your investigation, did you learn whether Chad and Lori were married?
Yes.
And what did you learn?
I learned that they got married November 5th, 2019.
And again, Tammy Daybell was pronounced dead on October 19th of 2019.
Yes.
Do you know when her funeral was?
October 22nd, 2019.
So just 3 days later.
Yes.
And I have no further questions.
All right, thank you, Ms. Blake. Cross-examination.
Judge, would you like me to start or do you want to take a break?
Why don't you go ahead and start and we'll take a break here in about 20 minutes or so, if that works. Can we have the microphone, please?
Officer, if you would allow me to either call you Officer K or I'm going to mispronounce your name for the next 20, 25 minutes.
That Officer K is okay.
Thank you. I appreciate that. Now, officer, you took the liberty of let me find this. Going through talking about your report about the emails between Mark Daybell and Tammy. Is that right?
Yes.
And Judge, I believe that was Exhibit 291. And if I could have 291.
Yes, we'll have the bailiff hand that to you or to the witness, Mr. Pryor,
Okay.
which,
Just to me. And Judge, if I could have permission to just publish.
you may publish that.
And officer, if you could tell me the date of that email.
10/13/2019.
Okay. And then that was obviously Dear Markey. That would be Tammy's son.
Yes.
Okay. And the very first sentence, it said, on Wednesday during the day, a lady pulled into the Price's driveway, grabbed their dog, drove off, right?
Yes.
Then she went on to talk about what transpired about that and about where they tried to locate where the lady lived. Is that fair?
Yes.
Okay. Now, from your investigation, were you able to determine where Regan Price lives?
Yes.
Where's Regan Price live?
Regan Price lives directly south of Chad Daybell's house.
Okay. And then that would be directly east of Joe Murray's house.
Correct. Yes.
So if we have if we can visualize this, we have Chad Daybell's property. And approximately how big is Chad Daybell's property? Do you know?
I'm not aware of that.
Okay. It's a more than an acre.
Yes.
Okay. And directly across the street from Chad Daybell's property is another house, correct?
Yes.
And then kitty corner to the south and to the west would be Joe Murray, right?
Yes.
And directly southeast of Chad's property would be Regan Price. Would that be fair?
Yes.
Okay, so 4 houses all kitty corner from each other. And this is more of a rural setting. Would you agree with that?
Yes.
And the houses are all on larger plots of property, correct?
Yes.
But the houses themselves are relatively close in terms of location. Would you agree with that?
Yes.
All of the houses on that particular corner, we heard on the 911, there was something about a flashing yellow light. And on that very corner, that's where all the four residences are located, pretty much on the corner of each of those, that intersection, right?
Yes,
Okay, so relatively close together are these homes that we've established that, right?
yes,
Okay, so one of the close neighbors is this lady by the name of Regan Price, correct?
yes.
And she talked about how somebody pulled into their driveway and grabbed their dog. Do you recall when that took place?
Well, in this email, she's writing it on the 13th about the night of the attempted shooting, so I'm assuming it was on the 9th.
Okay, so if you look at the very first line to her, she's writing this on the 13th to her son, which was a short time after the paintball incident. She says on Wednesday, during the day with Reagan outside. So can we presume that it was that Wednesday of that week?
Yes,
Okay. So at that point, somebody grabbed Reagan Price's dog, took off, stole the dog, and disappeared, correct?
yes,
And then now she says on the same day, you look down below to the second paragraph, right? You see that?
Yep. yes,
She was coming home from clogging. It was about 9:15 and she backed into the driveway. Okay. So the nose of her car was facing out of the driveway, correct?
yes,
Now, what I'd like to know is, you've been out to the house, right?
yes.
And how long of a driveway is that?
Front driveway, and I haven't measured it, but maybe,
I can make it easier for you if we could do it in
Yeah.
terms of an analysis. Would you be able to park 3 cars back to back in that driveway and not have any of them sticking out into the road?
maybe 2.5 to 3. Yeah.
Okay, 2.5 to 3 cars, maybe,
Yeah.
right? Okay, so and from your experience as a police officer, do you know the length of what the average automobile would be?
I'm not aware of that.
Okay, but if we took the size of an average automobile and we multiplied it times 2.5, that's how much space we're talking about, right?
Yeah.
And if you were looking at this bench in front of us, how many cars would you say could, were the jury sitting, how many cars could you push back to back in front of this bench?
Probably about 2.
Okay, so if we're asking about 2.5, would it be fair to say that the driveway was from the end of that bench to where this officer is?
Possibly.
Okay, so that's the length of the driveway. And at that point, from what I understand, according to this document, to Mark, she was getting some items out of the back seat and realized someone was at the back of the car. So she backed her car in and someone was behind her car. That would be near the garage. Is that the way you're reading that?
Behind her car, yes.
Okay, so someone was behind her car near the garage. She looked up thinking it was Dad or Garth to help her. Nope, it was a guy dressed in black with a ski mask on pointing a rifle at me. And she did say the word rifle, didn't she?
Yes.
Okay. And she went on to talk about that she was in shock because what do you think you were doing? Then the next line was starting with then. Would you read that next line for me?
Then I noticed the rifle was actually a paintball gun. It had a hopper on top.
Okay. Now, you know what a hopper is, right?
Yes.
You've seen a hopper?
Yes.
You know a hopper is different than a rifle scope, right?
Yes.
And you know that, Judge, I'm gonna. So in any event, you know that a hopper is a little different than a rifle scope, right?
Yes,
And you know that a hopper is a large composite of some kind container, right?
it's plastic container.
A big
Yes,
plastic container, right?
yes.
And would you agree with me that it would be very difficult to confuse a hopper with a rifle scope, right?
I wouldn't agree with you on that if you're
Okay.
not sure what a rifle is with a scope on it or a
Okay.
paintball gun with a hopper.
Did you happen to go over the report of Coulter Cannon?
I did.
Did you happen to go over uh, or discuss the case with Coulter Cannon?
A little bit, yes.
Okay. Were you aware that when Coulter Cannon came up to the residence of Tammy and Chad Daybell, that he went in the house and looked at one of the Google searches that Tammy was performing prior to the police arriving? Do you remember that?
I was not aware of that.
Okay. Or did you happen to look at Tammy's email and searches on that computer to determine whether Tammy had looked at anything prior to the police arriving?
Not on her computer, no.
Okay. Were you aware that Officer Cannon walked up to the computer with Garth Daybell and Tammy Daybell and proceeded to look at pictures of paintball guns?
I was not aware of that.
Were you aware that during the Google search by Tammy Daybell, that she pointed to the actual paintball gun that she saw the gentleman holding that day?
I was not aware of that.
Okay. Were you not aware of that because Coulter Cannon didn't include that information in his report not in his first report, right? That wasn't included in his first report, was it?
I didn't read that in his report.
Right. You didn't read it in his supplemental report either when he chose to supplement the report, correct?
Correct.
Okay. Now, Judge, previously we had stipulated to the admission of Defense Exhibit 14.
Okay, has it been offered or admitted yet, Mr.
I'm
Pryor?
going to offer it now, Judge, and ask that it be admitted. It was agreed to by stipulation.
Has the state reviewed Exhibit 14?
We have, Your Honor, but if I can be reminded of exactly what it is.
It's the Google.
All right.
It's the
Counselor.
searches, yes.
Well, let's do this. I want to go ahead and that may take a moment. I think it's a logical breaking point for our mid-morning recess. So I'll have the state review the exhibit that's been offered during the break. And let's try and come back on the record here in about 25 minutes or so. So about 10:35.
Thank you, Judge.
And the defense not putting in reputation evidence, right? We talked about this, Ms. Gianetti?
This is a motion to exclude good character evidence. Is that
It's paper number,
by the Commonwealth?
it was filed by the defendant, and I questioned whether you intended to put in character evidence, and you told me no.
That is accurate.
Okay, so that's allowed too, Jim.
Which one was that?
313, let me just check.
That's a Commonwealth one.
It is. Commonwealth's motion. It's 313, other Commonwealth date stamped, I guess, or date stamped 23.
Thank you.
There was no objection to the Commonwealth's motion eliminate to introduce certified records from the registry, correct, Mr.
Correct.
Yannetti? Okay.
Correct.
All right, and then motions that perhaps were not agreed upon, but I previously ruled on. So, or I think I ruled on them. If not, these are my rulings. 297, Commonwealth's number 7. Commonwealth's motion eliminate to preclude reference and redact the manner of death contained on the victim's death certificate. And I think I said in open court, this motion is denied as to cross-examination of the medical expert, but that undetermined language will not appear. That will be redacted from the death certificate. You'll have the live witness here to cross-examine us to that. So, Jim, that's 297.
Yes, Your Honor.
Commonwealth's motion eliminate to prohibit reference to any federal investigations, paper 317, Commonwealth bold stamp 27, to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office and or Federal Bureau of Investigations. That motion was allowed after hearing. 305 is the motion regarding chalks. We'll address that when we address the defendant's motion regarding their audiovisual person. The third-party culprit, the ruling's clear on that, not in opening. That's 320-30. I think that was clear when we talked about it. All right, so those are the ones that were fairly quick to just go through. I've got another set that are sort of in the fairly quick range. And then we'll move on to the Commonwealth's discovery type motions. So first, paper 284, defendant's motion for sanctions and exclusion of evidence based on the Commonwealth's failure to timely comply with discovery orders. Mr. Jackson, you told us at sidebar the other day that you are withdrawing that motion, correct?
Correct, Your Honor.
All right, so Mr. Clerk, that's motion 285, paper 285, withdrawn by counsel.
I'm sorry, Judge, 284?
Okay, I have it as 285. But
285 is the affidavit.
okay, yep, so 283,
Thank you.
withdrawn by counsel. Motion eliminate for review. So as defense counsel plainly states that a defendant is not entitled to be present at a view. And what I've determined here is that based on concerns for security issues and frankly distracting the jurors, the defendant will not be present with us on the view. And as you've stated here, that is well within my discretion. All right, Commonwealth's motion eliminate to admit defendants' out-of-court statements as statements of a party opponent. So I think that this was one of the ones that you all agreed to. Paper 308, 18 on the top, and it's followed by paper 19 regarding the various statements made to the media, to Boston Magazine, to ABC News correspondents. So I think the defendant had said previously that you were in agreement that all these statements come in. Is that right, Mr. Yannetti?
Sorry, Your Honor. Yes, that's correct.
All right. So I had a logistical question about, I don't know how long the ABC News interview is. How long is that?
Your Honor, what I can say is as to each of those, the Commonwealth's intention would be to play, to omit the entirety of the interviews, but to only play selected portions of those interviews.
All right, because what I did, I re-listened to the nearly 4 hours, 3 hours and 40 minutes of the Boston Magazine audio, and there's no objection to it from counsel. What I listened to, it made sense, and I didn't know how you would play a 3 hour and 40 minute audio. If you think you need to, we just need time to be able to put it into the schedule.
Sure,
Okay?
but no, I don't feel the need to play the entirety of it.
Okay. I was involved in a trial once where we watched a whole movie. So just give me a heads up if you think it's a lengthy segment. But how long is the ABC interview, just in case counsel wants to go back and fill in?
I think the portions that we have are not terribly lengthy. And as far as the statements are concerned, it's even less so of that.
All right. So does defense counsel intend to also play I'm trying to find out if we're going to need a whole 3 hour and 40 minutes. I need to know that. I still haven't got an answer as to how long the Dateline or ABC, whatever it was, video and audio is. How long is the entire thing? Do you know?
You're asking me?
Either of you. I don't have that, so I didn't review it.
May I have just a moment with
Yes.
counsel?
You're right. My memory and my belief is I think, and I can't recall specifically which one is one or the other, but I think one is about 10 minutes long, the other is about 5 minutes long, and again, I would only be playing, if any, portions of the defendant's statements, not the entirety of the broadcast.
Okay.
And if there are portions that weren't played, I would expect.
So that's what I'm trying to figure out. So I'm concerned on the 3 hour and 40 minute one, which seems to be all of it's admissible. There's no objection to it. And if, I just need to know if we're going to play something for 3 hours and 40 minutes. The other one, if it's 15 minutes, I don't need as much heads up.
My guess would be anything that we would want to present that wasn't presented would be in the 15, 20-minute
Okay,
category.
that's
not
fine.
3 hours.
It's just for scheduling purposes. Right. All right. So, Jim,
Yes.
paper 309 and 308, they're the same pretty much. Those are allowed by agreement.
Okay.
All right. And it's sort of in the same vein. So it's another statement of the defendant. It's the statement of the defendant at the Milton State Police Barracks that I had not seen before because it was post grand jury, and we watched it. I had the opportunity to watch what we all watched here in court last Friday, and over the weekend I watched the entire hour and a half or so of it. So you're in agreement that the statement comes in, and the Commonwealth says that the Commonwealth needs some leeway to show that she was in custody after arrest for a period of time, and Commonwealth wants to play the video. I don't think we need the video. Much of it is just looking at their computer. So the video part will be out. You don't want it in, correct?
That's correct. We had
Yes.
asked for the audio only.
Yeah. Okay. So the audio only, but it needs some context. It's not just that she's sitting down having a cup of coffee with the police and makes these statements. So they're clearly voluntary, clearly unsolicited. How do you want to work that out? Can it be that this occurred at the Milton State Police Barracks on a particular date? Because if you can't work it out, then I'll decide it.
That makes sense.
303?
Yeah, I mean, from our position, Your Honor, we don't object that the statements were made at the Milton State Police Barracks as they were, and it was in that context that she was speaking to the police at the barracks. We would object to introducing evidence that she was under arrest at that time.
Yeah, I don't think we need that. But so at the Milton State Police Barracks on a particular date.
That's acceptable.
Do you need more than that, Mr. Lally, for context?
No, Your Honor.
Okay. How is this going in?
Through the trooper to whom she was speaking.
Okay. All right. All right. So, Mr. Clerk,
Yes.
audio only. Commonwealth may elicit testimony. Statement occurred at the Milton State Police Barracks. Mr. Lally, do you remember the date?
June 9th, 2022.
Thank you.
22.
Yes.
Okay. So audio only, Mr. Clerk. Commonwealth may elicit testimony that the statement occurred at the Massachusetts State Police Barracks on June 9th, 2022. All right, so those are the fairly quick ones. Before we get to what I think are the more complex ones, or the ones that I need a little bit more argument from you on, I am concerned about discovery. So, Mr. Lally, when I was going through copies of what I had previously, the first time or one time that the Commonwealth filed on March 21st of this year a notice for reciprocal discovery and notice of experts. You then, last week, I think, filed a renewed motion for reciprocal discovery and request for voir dire of any defense experts. You asked that that be impounded. And that will be based on your motion and appears to be sort of an affidavit in support. So where do we stand with discovery?
So with reference to the reciprocal discovery, what Commonwealth is seeking is noted there are a number of witnesses listed on the defendant's witness list with no materials provided as to who these people are or what their intended testimony is. The issue with regard to experts is essentially there are 5 experts. Mr. Green, who there was an attachment to a motion with an affidavit and some materials. I think I have everything in relation to that. With regard to Dr. Sheridan, I have an affidavit and a curriculum vitae, and that's essentially it with respect to that. I just am inquiring as to whether or not there are any reports or any other sort of findings or anything post that. The other 3 experts all relate to that specific, I'm sorry. The next would be Dr. Van E., who...
Which, I'm sorry, I didn't hear you.
Dr. Christopher Van E.
Yeah.
I'm a little... so essentially there are that gentleman and then 3 individuals from this ARCA company who are all purported to be testifying in the area of crash reconstruction. None of them are crash reconstructionists. They're all biomechanical or biomedical engineers. With regard to Dr. Van E., who I've had some experience with in the past, my typical dealings with him is there's some sort of report written by him. I have nothing. I just have a CV and about a paragraph of what's anticipated as far as his testimony. The other 3 individuals, my issue is there is a report that's within the federal materials in relation to what they did. However, it's a single
In relation
report.
to what?
In regard to whatever examinations or tests or whatever that...
Does it include all 3 experts, though?
Well, so that's the issue.
Yeah.
The issue is the report is signed by all three individuals. So I have no idea who did what, who would testify to what, who has an opinion as to what, or what that would be. So I'm just looking for some additional information or any clarification as to what each of those respective people would be testifying to beyond just all three signed a report.
Okay, who's arguing this for the defense?
With the court's permission, I'd like to handle the issue regarding civilian witnesses and have Mr. Jackson address the experts.
All right.
My argument's very brief, Your Honor. We're well aware of our obligations under Rule 14, and any statements that we have regarding civilian witnesses that fall under that rubric, we will turn over, and we have turned over.
But why haven't you?
No, we've turned over what we have. So in our view, we've complied with discovery with regard to the civilian witnesses that Mr. Lally speaks about.
All right. Do you have addresses for those witnesses, Mr. Lally?
We did it. Yeah.
All right. So they need addresses, right? If there's nothing there, they need the addresses so the police can go out and interview them.
We will get them addresses by the end of the day today.
Okay. All right. So my concern was that when, Mr. Lally, when did you file your certificate of compliance?
That would have been, I believe the Wednesday, not last Wednesday, the Wednesday before that.
And I had previously told counsel I would expect within 2 days of that because obviously you've been preparing this case for a long time.
Of course, yes.
But so to have Mr. Lally stand here today and say that he doesn't have all this information that you know he's entitled to, I mean, dates of birth and addresses of witnesses are pretty standard, Ms. Giannetti, especially if you have, not provided anything that they're going to say. So that should have happened a week ago.
Your Honor,
If I may defer to my co-counsel.
Well, okay. And we do have to talk about how we're going to do this at trial. Okay.
Yes.
Your Honor, I provided reciprocal discovery to Mr. Lally within 24 hours of receiving the certificate of compliance.
Anything about these witnesses that Ms. Giannetti says they have everything on?
Yes, he's received statements from all the witnesses that we have statements for, which included their dates of birth, addresses.
How many is that, Ms. Little? How many witnesses?
I don't know off the top of my head, but every single report that we have for these witnesses that Mr. Lally has received in his witness list, he has reports for.
Okay.
And a number of our witnesses, obviously, are witnesses that the Commonwealth has interviewed.
Right. I think I crossed out much of your list when I read the names of the witnesses, right? Because they were duplicates.
So we have complied with at least those obligations. And if there's any addresses that we haven't produced, I will make sure that gets done today. But he should have the vast majority of everything.
All right. Anything specific, Mr. Lally, on the civilian witnesses?
Well, just in looking at the defense witness list, there are 77 witnesses that are listed. 35 of them are on the Commonwealth's witness list, and I have statements from 4 witnesses, not including experts, so that would probably make it to 9, or if you include the investigator, 10 or 11. So there's still a substantial amount of witnesses that I don't have addresses, date of birth, or any statements from, or even what their anticipated testimony would be.
Your Honor, there's also probably an additional 10 to 12 witnesses that he has reports for from the federal materials, which include addresses, statements, that type of information.
All right. It's my view that that's still the defendant's obligation to provide, all right, or at least acknowledge where they are. All right. Let me hear the expert response, Mr. Jackson.
Your Honor, with regard to Dr. Vanny, Chris Vanny, first of all, he is technically a rebuttal witness. There's a trooper named Trooper Paul that's going to be called in the Commonwealth's case in chief, and he's going to testify to some key cycle information. Key cycles are trigger events or cycling events with regard to the SUV. Chris Vanny is expected to testify in rebuttal to Trooper Paul's testimony that his Trooper Paul's analysis of the key cycles is flawed in terms of timing. And the number of key cycles that he relates back to an event that takes the SUV back to 34 Fairview. So Chris Vanny has done a similar analysis, or at least overviewed or looked over Trooper Paul's analysis and has determined that Trooper Paul's analysis is incorrect. So we included his name, although he's a rebuttal witness, we included his name just to be in an abundance of caution. He has not produced a report.
do you have to at least tell the Commonwealth what he bases his opinion on, what he has viewed, what he bases his opinion on?
The exact same information, the raw data that Trooper Paul based his opinion on.
All right, so is this the first you're hearing this, Mr. Lally?
There's kind of a vague description to that effect, but again, what I'm hearing is similar to that in the sense of he disagrees with the Commonwealth's expert, but I don't have any foundation for that or what specifically he disagrees about or what his points of contention would be with Trooper Paul's report as far as no report, no basis of opinion, no anything of that nature. That's my concern.
Okay. And you've requested a voir dire
Yes, Your
of
Honor.
the experts? All right. We don't want to bring this witness out here early for a voir dire, so I suggest you get the information that was requested.
I'll be happy to.
If we have to bring him out, we have to bring him out.
No, I'm not looking to bring him out, and I don't think that he needs to be voir dired. He's going to look at the exact same, and I'll call Mr. Lally and explain to him what I think in a little bit more granular detail is going to be the sum and substance of his testimony. But Mr. Lally he certainly can conceive, as Trooper Paul walks through his analysis, Chris Van E is going to walk through the exact same analysis. It's the same data set. They're both working with apples and apples. He just has a different conclusion that the key cycles are not in keeping with what Trooper Paul analyzed because he left some key cycles out. Pretty simple stuff. But I'm happy to contact Mr. Lally offline and let him know exactly what it is that
All
has a
right. All
problem.
right. So you do that, and if it's not resolved by Monday, we will pick a date within the next week to have voir dires of whatever experts that insufficient discovery has been provided to the Commonwealth on. So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what?
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10 page report that's detailed, single spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who did what. So.
Okay, I'm happy to talk to Mr. Lally about that. I believe the answer is going to be, in sum and substance, all of them work together as a team to come to the opinions and conclusions that are recited in the report. But I'll be happy to have an additional conversation with Mr. Lally about that. I don't know that I know every single thing. As a matter of fact, I don't know every single thing that everybody did, who screwed what bolt into what nut, et cetera. But I think by and large, Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
Okay.
And by the way, they are accident reconstructionists, so there's a...
Do you have their CVs?
I do, and so does Mr. Lally.
I do.
Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications. I don't think meet that standard for them to be able to testify in that area.
All right. So two things. When the two of you are working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started. Or if it can be done before the witness testifies.
Okay.
All right.
Understood, Your Honor.
All right. So Commonwealth's motion for voir dire. Of any witness to be asked for opinion or character of defendant or any witness. I had that this was allowed by agreement, 314, DS number 24.
That's agreed.
And 304, Commonwealth's bolded number 14. Commonwealth's
There was a question on Exhibit 14 and whether or not that would be admitted by stipulation. Did council resolve that?
Your Honor, I have had a chance to review that, and it is data recovered. It's a report referencing data recovered from Tammy Daybell's phone, and the contents of her phone were stipulated to. So we wouldn't have an objection.
Okay, so we'll just go ahead and admit Exhibit 14 once the jurors return, so they hear that.
Judge, I have a picture as well, and the state has a picture of their own. I guess we're going to play dueling pictures. Mine I'd like to mark as 14A. I don't know what the state would like to have theirs marked as.
Yes, it was the photo that Mr. Pryor showed us and then didn't actually move for admission of because we hadn't seen it before today. We would not object to the admission of that photo.
Can you use the microphone, please? We just got to get the record of this, Mr. Pryor.
And Judge, I also just saw their picture today, so I will stipulate to the admission of their picture as well. But mine is 14A if the bailiff wants to.
All right. Are you requesting that the bailiff retrieve that exhibit so it can be marked?
So it can be marked and accepted, Judge, as 14A.
Thank you, Mr. Bailiff. And we can have the jurors brought in once they're ready.
Sure.
Thank you.
All right, please. Who's up, President Cataford, Your Honor?
Thank you, Mr. Bailiff. Please be seated. Okay, we're back on the record. The jurors have returned and are properly seated. I'll note the parties were able to review those exhibits and have offered, and at this time the court will admit Defense Exhibit 14 as well as Defendant's Exhibit 14A, both admitted. You can continue with the cross-examination, Mr. Pryor.
Judge, if we could put the monitor back up with what I was discussing, which I believe was Exhibit 291. Now, officer, prior to taking our break, I think I was talking about the third paragraph down. And would you do me a favor and read the first two sentences of that?
Are you referring to the one where it says?
I think,
okay. I think I was a bit in shock because I just said, what do you think you were doing? Then I noticed the rifle was actually a paintball gun. It had a hopper on top.
Then the next line says, the guy started pulling the trigger and I could just hear the clicking and whooshing sound of an empty paintball gun. Is that correct?
Yes.
Okay. He stayed there standing by the back of the car, just pulling the trigger while pointing the gun at me. For some reason, I just kept asking him what he thought he was doing. Now, she did say in the sentence, just pointing the gun at me. And we don't know whether she meant a gun or whether she meant paintball, correct? Because she identified it as a paintball, but she did use the gun on that sentence, correct?
Yes.
But we don't know whether that was a mistake or whether she just decided not to type the word paintball in, right?
Correct.
Right. Okay. Then I just asked him at what point I was actually more annoyed than scared because he was standing between me and the door. and he didn't step toward me or even say anything. Okay. Okay. So, from what I understand, when she was backing up, then the front of the door is really right next to the garage, right?
If I remember right, yes, it's a little sidewalk up to the garage or
Yeah.
to the main door.
And that sidewalk's probably less than 5 feet, correct?
I couldn't testify to that. I'm
It's a
not sure.
short sidewalk,
Okay.
though. Well,
I-
not okay. Do you
I can't testify to that.
Objection, Your Honor. Counsel's adding facts, not in evidence.
That's sustained. And in addition, please don't talk at the same time as each other. Mr. Pryor, wait for a concluded answer before you ask a new question.
Would you agree that it's a short sidewalk from the gate into the yard to the front door?
It is a short sidewalk, but I can't testify to how long it is.
Okay, that's okay. Now, from this description, this person was standing between the door and the garage at the very back of Tammy's, where Tammy's car was backed in, correct?
Yes.
So in other words, that was something that was at relatively close range. Would you agree with me?
Yes.
And in that sense, being at such close range, you'd probably get a pretty good look at what type of instrument was being pointed at you. Would you agree with me in that regard?
Objection, Your Honor. Calls for speculation.
Overruled.
Would you agree with me in that regard? When it's something that close to you and you're looking at it, you'd be reasonably certain about what you're looking at, correct?
It was in the daylight.
Okay.
Yes.
Okay. Now, we can all agree that the manufacturers of paintball guns make them in various shapes and sizes, correct?
Yes.
And the manufacturers of these guns get some benefit by making some of these guns look similar to weapons, right? Real weapons.
Yes.
And they can make them quite authentic at times, correct?
They can be, yes.
Right. But there is one thing that distinguishes a paintball gun between a real gun, and that is a hopper, correct?
Like you just mentioned before, the manufacturers are coming out with new guns. So yes, a hopper is one, but there's many other ways that paintballs can fit into a rifle without a hopper.
Okay. Okay. So in other words, unless we actually had this weapon in hand, we really don't know which one it is. Would that be fair?
Yes.
Okay. Okay. Now, please correct me if I'm making a mistake, but without a suppressor, a AR-15 is a very, very loud gun, isn't it?
Yes.
And even with a suppressor, an AR-15 is not silent. It still makes a pretty loud noise, doesn't it?
It depends what kind of ammunition you're using.
Okay. Well, what kind of ammunition was in this gun?
That I don't know.
Well, you don't even know if it was a gun, do you?
I know it was a paintball gun or a rifle that she referred to.
Okay. Okay. But depending on the ammunition, there's still going to be a loud noise, right?
Are you asking with the suppressor on or off?
With the suppressor on, there's still going to be a noise, right?
There will be a noise, but not as loud depending on what
Okay.
ammunition you're using.
Okay. And when you're just several feet from the front door of a house with Garth Daybell and Chad Daybell inside the house, you would think they would have heard a gun if even with a suppressor, you think they would have heard the rifle shoot, right?
Again, it depends on what ammunition is
Okay.
being shot through the gun.
But what we do know and what we're certain of is that when a paintball gun is shot, they can't change the fact that there's a whooshing noise, can they?
There's a popping noise with the clicking,
And a whooshing noise.
whooshing and popping.
Right. Okay. Okay. So when Tammy Daybell in this report talks about the whooshing noise that she heard, sounds like she's describing the whooshing noise from a paintball gun.
Objection, Your Honor. Move to strike. Counsel's testifying.
Sustained.
Did it sound from this email that Tammy Daybell's describing the whooshing noise of a paintball gun?
She said she heard a clicking and whooshing.
Okay. Okay. Now, We move further down and we talk about where it says the thought crossed my mind to hit him with my clogging shoes. Looked toward the house and yelled, Chad. They ran off around the north side of the house. You see that?
Yes.
Got Dad and Garth. They looked outside, couldn't find them, called the police, reported it. Then she uses the term, they suspect it was a bipolar teenager who lives down the street and walks around a lot, but Matt Price has an even better theory, right?
Yes.
Okay. So it's really unclear who they say they suspect it was a bipolar teenager. They don't know if we're talking about the police told them or whether it was Chad and Garth said it was a bipolar teenager. Is that fair?
That's fair.
Okay. So when Officer Coulter was on the stand, I had spoken to him about the fact that in his report, he didn't mention anything about a bipolar teenager running around the neighborhood, harassing people. Were you aware of that at the time of this offense?
Objection, Your Honor, calls for speculation.
Overruled.
Were you aware of the fact that there was a bipolar teenager running around the neighborhood? Maybe I want to be careful with my words. Contacting the people in these neighborhoods?
I was not.
Okay. And are you aware whether or not you ever discussed that with Officer Coulter?
I can't recall if I did or not.
Okay. Did you discuss that with any of the other officers who were there at the time of this paintball incident about this bipolar teenager?
I did not.
Okay. Then we go on and we talk about his theory and his theory is that the crazy dog lady brought her husband back to steal the dog again. They had parked on the road and had snuck through the cow fields and he was going to cut through our front yard. So that's a couple of things. Park down the road, cut through the cow fields. Is that the Daybell's cow fields?
I can't testify if that's what she's referring to, because
Okay.
there are a couple others out there.
Yeah, but there are cow fields next door to the Daybells. The Daybells have a pasture behind their property as well, correct?
Yes.
And then they said they were going to cut through our front yard. So that would mean Chad and Tammy's front yard, correct?
Yes.
When I pulled up and startled him, he didn't know what to do. So he panicked and tried to menace me with his not real gun. So at that point, she's pretty clear that she knows it's a not real gun. Would you disagree with that?
Objection, Your Honor, calls for speculation as to what Tammy knew.
Sustained.
Well, she put in a,
Objection, Your Honor, narrative.
Yeah, Mr. Pryor, I ruled on it.
Okay.
So ask a different question.
so after the line that says it was a not real gun and then ran off back across the field, which would explain why he ran across the side of the house. I never heard a car and we couldn't find anywhere. You see that?
Yes.
And then she wrote, it's actually a pretty good theory. You see that?
Yes.
Did you guys interview Regan Price?
We spoke with Regan Price. Yes.
Okay. Did you talk to Matt Price?
Yes.
Okay. And did they confirm the fact that someone stole their dog around the close in time to this occurrence?
I'd have to go back to my report. I know we spoke with them after this incident, quite a ways after this.
Okay. But you do know that this incident with the dog, I believe it occurred on the same day that the paintball gun took place. Is that right?
Yes.
And the issues about the bipolar teenager running around the neighborhood, that was close in time as well, correct?
That was Matt's theory. Yes.
Okay. And then finally, honestly, would you read the word honestly down to the end of the paragraph?
Honestly, I just kept wondering what kind of person walks around with a ski mask on, carrying an empty paintball gun. Bipolar doesn't mean you want to hurt people So I'm leaning more towards Matt's theory. The guy didn't try to rob me or even really hurt me. On Thursday night, though, I didn't go to Zumba because I quite understandably did not want to be out after dark alone.
So in this particular incident, it's saying that I'm leaning towards Matt's theory. The guy didn't try to rob me, or the guy didn't try to hurt me. So she wasn't threatened by someone holding a paintball gun like a rifle, right?
Objection, Your Honor. Calls for speculation and mischaracterizes this email.
Sustained.
And Judge, I need to go back to I'd like to go back to 232B, and I'd like to republish that for the jury, Judge.
All right, we'll have the bailiff provide that to you, Mr. Pryor.
And Judge, if we could just wait till I get it brought up. I think I'm ready, Judge. Let's hope.
All right, you may.
Second. Fremont County Sheriff's Office. Hi, I need to report something. Okay, go ahead. What's the address? Okay, at 202 North, 1900 East, the corner with the blinking yellow light on Salem Highway. Is it a suspicious person? Yes. Okay, what was he wearing? He was all dressed in black and he had a ski mask on. And he said the blinking light now is where you saw him? No, he's gone now because I pulled up into our driveway and I was getting stuff out of the back seat of my car and suddenly he was there and he had a paintball gun and he was and like he was going to shoot at me. And I kept asking him what he was doing because I could tell it was a paintball thing. Okay. And then he just kept doing it. So I yelled for my husband and then he took off running around the back of my house. Okay. Give me just 1 minute. Stay on the line with me. Okay.
October 9, 2019, 21 hours, 50 minutes, 28 seconds.
And that was North 1900. Yes.
October 9, 2019, 21 hours, 50 minutes, 43 seconds.
In what direction he was going? He went behind my house and it's so dark out here and I just went in the house and got my husband and son and then they went out and looked and he was long gone by then. Okay. So he was on the north side of my house is where he went to get away. Okay. He didn't say anything or he just kept like he was holding the gun like he was, had a rifle and just shooting at me. So. But nothing came out of the gun either, so I don't think it was loaded. Okay, and what is your name, ma'am? My name is Chad Daybell. Okay, I will pass your information on to my deputies. We actually just had a previous call about this individual, so they're out in the area looking now. Okay, yeah, I think it was my son-in-law who lives diagonal from us that called you guys already. Oh, but okay. Just wanted to make sure it got reported. So, let's see. And what's your son-in-law's name? Is it Joseph Murray? Okay, yep, it was him. Okay. So, all right, I have a deputy that will be out at your home here shortly. Okay, thank you. Yep.
At some point, Judge, I'm also going to need 232.
Into the microphone, please, Mr. Pryor.
I'm also going to need 232A at some point, but I'd like to discuss 232B. You listened carefully to the 911 call from Tammy Daybell. Is that right?
Yes.
Now, she said paintball a number of times during that 911 call, correct?
Couple times, yes.
And then at the end, she said, holding the gun like he was holding a rifle. She never said he was holding a rifle, did she?
I think you just stated it. He was holding a gun like the rifle.
She never said she was holding a rifle, did she?
Objection, Your Honor. The audio speaks for itself.
Sustained.
Okay. There was no discussion about a specific rifle. Was it not the manner in which the gun was being held? That was what we heard?
There's no specific rifle that she named, no.
Okay.
There was no specific rifle that she named.
Okay. Well, she didn't even say it was a rifle, did she?
She said a gun and a rifle.
Well, she said a gun holding like a rifle. Isn't that what she said?
Objection, Your Honor. Again, the audio speaks for itself.
Sustained.
Judge, I should be allowed to go into whether or not the manner in which.
Then replay that section, Mr. Pryor,
Okay.
if you want to make it clear, but to just keep asking on the audio we just listened to is improper.
Bailiff, could I have 232 again, please? I think I want A. Thank you. So Judge, again, we'll ask to publish 232A again.
I believe we just published 232B.
Backwards, excuse me.
Okay.
I apologize. I think I'm ready, Judge.
Go ahead.
20 seconds.
Vermont County Sheriff's Office. Hi, I need to report something. Okay, go ahead. What's the address? Okay, at 202 North, 1900 East, the corner with the blinking yellow light on Salem Highway. Is it a suspicious person? Yes. Okay, what was he wearing? He was all dressed in black and he had a ski mask on. And he said the blinking light now is where you saw him? No, he's gone now because I pulled up into our driveway and I was getting stuff out of the back seat of my car and suddenly he was there and he had a paintball gun and he was and like he was going to shoot at me. And I kept asking him what he was doing because I could tell it was a paintball thing. Okay. And then he just kept doing it. So I yelled for my husband and then he took off running around the back of my house. Okay. Give me just 1 minute. Stay on the line with me. Okay.
October 9, 2019. 21 hours, 50 minutes, 28 seconds.
That was North 1900 East? Yes. Okay.
October 9, 2019. 21 hours, 50 minutes, 43 seconds.
In what direction he was going? He went behind my house and it's so dark out here and I just went in the house and got my husband and son and then they went out and looked and he was long gone by then. Okay. So he was on the north side of my house is where he went to get away. Okay. he didn't say anything, or he just kept like he was holding the gun like he was, had a rifle and just shooting at me. So, but nothing came out of the gun either, so I don't think it was loaded.
Okay, and what is your name, ma'am?
My name is Tammy Daybell.
Okay, I will pass your information on to my deputies. We actually just had a previous call about this individual, so they're out in the area looking now.
Okay, yeah, I think it was my son-in-law who lived diagonal from us that called you guys already.
Oh,
But we
okay.
just wanted to make sure it got reported. So,
Let's see. And what's your son-in-law's name?
Joseph Murray.
Okay, yep, it was him.
Okay.
So, all right, I have a deputy that will be out at your home here shortly.
Okay, thank you.
Yep.
We can agree then that the 911 call would speak for itself, right?
Correct. Having a rifle and shooting at her.
Having a rifle and shooting at her.
Having a rifle and pointing at her.
Is that what you heard?
Yes.
Okay, but I guess we can let the jury make a determination about what they heard, right?
Yes.
Now, we previously talked to, and Judge, I'm going to ask to publish 14A.
All right, do you have that with you?
I do, and it's already been admitted and accepted.
Okay, 14A may be published.
Officer, you're looking at what's been marked as Exhibit 14A, is that right?
Yes.
Okay. Now, there's a big black round thing on the top of that gun. Do you know what that is?
That's a hopper.
Okay, and it's pretty distinct, right?
Yes.
Pretty clear to identify that it's a hopper on the top of a paintball gun, correct?
Yes.
So if someone is in a situation where they're looking at something and they're clearly able to determine that there's a hopper on the gun, this would be a situation where they'd be able to clearly see that there's a hopper, correct?
If they're clearly able to see that, then yes.
Okay. So if someone through their testimony talks about being able to clearly see that there's a hopper on a gun, that's a distinguishing fact, that's a distinguishing feature of a paintball gun. Is that correct?
If they clearly see it, yes.
Yeah, and if they're able to identify the fact that a particular paintball gun has a hopper and they can identify the hopper, it's obviously they saw a hopper, right?
Objection, Your Honor, calls for speculation.
Sustained.
Okay. But you spoke about it a little earlier where you said they're now designing paintball guns that look like rifles.
Yes.
And they're being very creative in doing that, correct?
Yes.
In fact, I would suggest to you that there are instances where people have manufactured paintball guns to make the scopes on a gun look like a hopper. Correct?
Are you suggesting that to me
Yeah,
or asking?
yeah,
me?
I'm suggesting that, asking you that.
Possibly.
Possibly. Okay. So if that were one of those special guns where they created a gun that had something on it that looked like a scope, someone could confuse the difference between a scope and a hopper, right?
Yes.
But if someone specifically says they saw a hopper on a gun, there's no
Objection, Your Honor, this is going to call for speculation.
Sustained.
clearly that was a picture of a hopper on the gun, right?
During the day, yes.
Yeah, and you're able to distinguish that very clearly, right?
In the daylight, yes.
Oh, you're telling me that there's a difference? You wouldn't be able to tell that in the night on the back of a porch with a light on?
Objection,
Oh.
Your Honor, argumentative.
Sustained and strike the answer.
Are you aware of that there are lights on the front of the garage of the Daybell residence?
I was aware on that last call you played that Tammy Daybell said it was dark outside.
Right. but you didn't hear anything about the fact that there were lights out there or that the garage and the driveway was illuminated, right?
I didn't hear any of that.
Okay. I didn't know if I heard an objection or not, Judge, to that.
Withdrawn.
Go ahead.
Okay. But you did note that she identified it as a paintball gun, didn't she?
She used that with a rifle and gun.
Okay. And whooshing sound, right?
Correct.
Okay. Now, Judge, I believe that Exhibit 16 was previously admitted. If I could have the bailiff bring me Exhibit 16. And Judge, if I could just have a moment, please.
Yes.
Thank you, Your Honor. Now, Officer, are you aware as part of your investigation that Tammy Daybell sent out a Facebook posting to what she described as the Friends of the Salem Ward? Do you recall looking at something like that?
I remember she sent something out on that, yes.
Okay, okay. You don't have a recollection of what it said though, probably, correct?
Not exactly.
And Judge, could we publish Exhibit 16?
You may.
I have it ready to go, Judge, whenever the clerk is ready. Okay, I don't know if I can expand that or not, Judge. No. Are you able to read that, officer, on your monitor?
Yeah. Yes.
Okay. Go ahead. Would you read that email for me?
Something really weird just happened, and I want you to know so you can watch out. Had gone home and parked him out in our front driveway. As I was getting stuff out of the back seat, a guy wearing a ski mask was suddenly standing by the back of my car with a paintball gun. He shot at me several times, although I don't think it was loaded.
Okay, you can stop there. So again, and this email that you said you reviewed was to the Friends of the Salem Third Ward. Do you know what the Salem Third Ward is?
Are you referring to the Facebook or the email?
Facebook, the Facebook here that was sent out.
Okay. I'm not just a church ward,
Okay,
the Salem Third Ward.
okay. You've heard of that before? You've heard
Yes.
of the Salem Third Ward before?
Well, I'm assuming it's their church they go to out that way.
Okay, you don't know how large of a ward that is or how many members they communicate to, right?
I don't.
Okay, but you do know that she got on there at this point and discussed the incident that took place, correct?
Yes.
And did she ever use the term rifle in this Facebook posting?
No.
Did she ever use the word gun?
No.
But she did use the word paintball gun, correct?
Yes.
Okay. All right, Judge, I'm done with that. Thank you. And Judge, I have, I don't. If I could just have a minute again, Judge, I apologize.
It's fine.
Now, um, Judge, I need the court to advise whether or not Exhibit 15 has been admitted or offered for admission.
We'll check. No.
And I guess I have to pull this out and Judge ask that the court, I think this is by stipulation of the parties. Exhibit 15 has been stipulated by the parties to be admitted, and I'd ask it to be marked and accepted with the court, Exhibit 15.
All right, I'll confirm with the state.
Yes, Your Honor, I believe that this is a segment of the data recovered from Tammy Daybell's phone, and the contents of her phone have been stipulated to.
Okay, so Exhibit 15 is offered and will be admitted.
Now, before I go into Exhibit 15, Officer, you discussed that you did a lot of discovery and looking at what was the term you used? What?
Geofencing?
Geofencing. And when you're looking at phone records and emails and Facebook postings, sometime there's a reference after the time that indicates the letters UTC. Are you familiar with what UTC means?
I've heard the term. I'm trying to think. I believe it's a couple hours off of certain time zones.
Okay. And are you aware that in Idaho, it's a universal time zone equation that they put together, right? So that the whole world is on the same time zone, correct?
I believe so, yes.
Right. And are you aware that Idaho is when there's a UTC, you have to actually subtract 6 hours from the time that's noted on a UTC. Does that sound about right?
I know you had to subtract, I'm not sure if it's 6 hours, but yes, I do know you had to subtract some hours.
Do you have any reason to believe that it's not 6 hours?
No.
Okay. Okay. Now, I'd like to go back to the call from Tammy Daybell. And if you don't remember, it's fine. But the call to 911, do you recall what time that call was made? Is there some kind of report you could refresh your recollection with quickly?
Well, I know there was two that came in, one from Joseph Ryan and Tammy. I believe hers was around 9:41.
Okay. Okay. And then hers was 9:41?
I believe so.
Or 9:51, somewhere in there.
I'm not 100% sure on that, so I guess I can't testify truly on that.
Okay. Okay. But it was clearly after 9:30 though.
Objection, Your Honor. The officer just said he couldn't testify to that.
Sustained.
Okay. Okay. Judge, I'd like to put up Exhibit 15 for publication.
You may publish.
I'm ready, Judge, whenever the clerk is. I'm showing it, Judge. I'm not sure what.
All right, we'll see if we could get someone to maybe take a look at.
Oh, I think we're there.
Okay.
I just had to wiggle a little. I had to wiggle the cords a little bit. Okay. So can you see that from your screen, officer?
Yes.
Okay. And I would represent to you that this was off of Tammy Daybell's account, stipulated by the parties as a retrieval of her Google searches. Can you read the very first one?
Search for a paintball gun,
Okay,
paintball
and then
guns.
we talked about the UTC and well, I guess I suggested it was 6 hours. You didn't really specify, but would you read the date of when that was done, that Google search was done?
October 10th, 2019.
Okay, October 10th, 2019. And the time on that, the UTC time would be what?
If it is 6 hours, it would be 9:29.
On the 18th.
Correct.
Okay.
On the 10th.
Oh, you're right. I'm sorry. All right. So the day that this incident took place was what?
October 9th.
Okay. And the UTC, if it goes back 6 hours from AM at 3:29 AM on the 10th, going back 6 hours, wouldn't that put us at 9:30 on the 9th?
Yes.
Okay. So at well, actually, let's be clear, 9:29 on the 9th, right?
Yes.
Okay. So at 9:29 on the 9th of October, there was a Google search by Tammy Daybell searching out paintball guns, correct?
Correct.
Now, I don't remember seeing a discussion with Officer Coulter in I guess it was his second report, where he talked about that Tammy Daybell did a Google search on paintball guns.
Objection, Your Honor. Counsel's testifying.
Did you see that?
Wait. Objection pending. It's sustained.
Did you see a reference in Officer Coulter's second report about Google searches at 9:29 on the 9th of October?
No.
Okay, well, your previous testimony was that Tammy Daybell made a 911 call sometime 9:41 is what you recalled. But the Google search occurred at 9:29. Is that what you see?
Yes.
So what we can gather from that is that Tammy Daybell, after this incident, did a search of paintball guns and then 10 minutes later called 911, right?
Yes.
Okay, do you remember what the date of the Facebook posting was when she posted that Facebook?
I do not recall that date.
Okay. And then let's move down a little bit. The next one.
Search for an airsoft guns.
Okay. And again, the time.
October 10th, 2019 at 3:29.
So basically, if we go back to UTC time, we're back at around 9:30 again, right?
Yes.
So her Google searches at that point, and just for everybody's edification, we don't need to go down the other ones because they're not relevant to this. But the first two, the first one was a paintball gun search at 9:29, right?
Yes.
Then she looked for an airsoft gun search at 9:29, right?
Yes.
Did she ever look for a rifle?
She did not.
Did she ever look at any other shotgun?
She did not.
Okay. Okay. Thank you, Mr. Bailiff. Nobody was there from your agency at the time of this incident with Tammy Daybell and this person. Is that correct? That she was allegedly shot at?
We responded to that.
But nobody was there when it occurred.
Correct.
And in fact, Chad wasn't there either, right?
Objection, Your Honor. Calls for speculation.
Sustained.
Well, you know from the report that Tammy talked about Chad and Garth coming out afterwards, correct?
Yes.
And there's no indication at the time of this occurrence that there was anybody other than a masked man and Tammy Daybell. Is that right?
And in Tammy's email, Chad and Garth.
Well, Chad and Garth were inside the house, right?
Yes.
Okay. So at the time of this alleged shooting, the two people would be a masked man and Tammy Daybell. Would that be fair?
Outside of the residence, yes.
Okay. So the best person to determine what type of instrument this was would be one of the people who was there at the time, right?
Objection, Your Honor, calls for speculation.
Overruled.
Your Honor, may I voir dire a native objection?
Well, just the way that question was phrased, I'm overruling that. It was just of the two. Go ahead and re-ask the question, Mr. Pryor.
The best person to determine what type of instrument that was would have been Tammy Daybell, correct?
One of the
Objection, Your Honor.
Grounds.
It calls for speculation. May I have voir dire a native objection?
Go ahead.
Detective Kaikamanu, did you ever have an opportunity to speak with Tammy Daybell?
No.
Do you know, did you ever determine her knowledge of firearms?
No.
Do you know her experience with paintball guns?
No.
Do you know her experience with firearms?
No.
So do you know if she'd be able to tell the difference?
No.
Your Honor, I'd object to that. It calls for speculation.
All right. Well, I am going to overrule it on the speculation objection, but of course you'll be able to redirect Ms. Blake.
Yeah. So again, you actually corrected me. There are two people there that would know what type of instrument that would do. Two people that would be the best people to identify what kind of instrument, correct?
Correct. One of the two.
Yeah. The person in the ski mask would be one. We don't know who that was, right?
Correct.
And Tammy Daybell.
Yes.
Okay. Okay. Thank you. Officer or Judge, I'd like to now go through on the Elmo Exhibit 107, if I could.
You may.
Thank you, Your Honor.
We'll allow that to be published. It's already been admitted.
Obviously, during your talk with the prosecuting attorney, this has already been admitted, and you went through that. You recall that, right?
Yes.
Now, as part of your examination, you provided records from Fremont County Sportsman's Club, right?
Yes.
And you did the start date of sometime of 10/16. Is that right? Is that what you recall?
The start date of
Of when the documents that you provided to the prosecuting attorney. The first entry on there, it looks to be about 10/16. Am I mistaken?
I'd have to relook at those.
Okay, Judge, could we show this to the witness to refresh his recollection? When you're done, just hand it back. Thank you, sir.
Yes.
And Your Honor, may the state know what's being shown to the witness?
Which exhibit did you just reference?
It's their exhibit of the entries to the visits to the Sportsman's, I don't want to misstate the name of the organization, the Sportsman's Gun Club.
Thank you.
That is exhibit 390A. I'm sorry, 396A.
Okay, and if I could have that back. Now I'm looking at this exhibit and it appears that it starts on 10/16. Is that right?
That's correct.
Okay, now did you happen to take the time to look at the entries prior to that time?
Prior to 10/16, yes.
You did.
Yes.
And Alex Cox arrived in Idaho from what you learned from your investigation about when?
On the 1st of September.
So on the 1st of September. So after arriving, as part of your investigation, what did you discover from September 1st to October 15th in terms of the number of times that Alex Cox visited the gun range?
Give those dates one more time.
September 1st we'll just make it October 15th.
So Alex Cox, from my knowledge, was at the gun range in St. Anthony from October 7th to the 16th.
Okay. And you don't have any entries of him being there in September?
Not at the Fremont County gun range, no.
Do you have him at any other gun range in the month of September?
I believe there were some in Rexburg, Idaho.
Okay. And when you say some, that would indicate that there were more than 2 or 3. Is that right?
Correct.
Okay. So he'd had a habit. You also had an opportunity to review the searches of Alex Cox on his computer as well, correct?
I don't believe on his computer.
You
no.
didn't review any of that?
I reviewed some of the Homer J. Maximus. I'm not sure if that was off of his computer or not.
Okay. But as part of the Homer J. Maximus, are you aware that Alex Cox had been looking at weapons as early as 2017?
I was not aware of that early. No.
Okay. Well, how early were you aware of when he was looking at weapons?
September, October of 2019.
And that's because that's when you went, that was your reference point. September 1st is when you started your reference point, right?
What I looked at, yes.
Yeah. So you didn't really go back and look at all of the searches that Alex Cox conducted prior to September of 2019, right?
I did not.
Okay. Okay. But you are aware that Alex Cox has a history of engaging in the use of guns or other weapons on folks, right?
Objection, Your Honor. States facts not in evidence.
Overruled.
Are you aware, and I'll rephrase that, you're aware of the situation regarding Brandon Boudreaux, right?
Yes.
And you're aware that it's alleged that Alex Cox at a long distance shot at Brandon Boudreaux, correct?
Yes.
Okay. And you're aware of Charles Vallow, correct?
Yes.
You're aware that Alex Cox took a gun and at close range murdered Charles Vallow, correct?
Yes.
And you're also aware that in both of those instances, Chad Daybell has not been criminally implicated in either of those cases. Is that correct?
Yes.
And Chad Daybell has not been charged in either of those cases. Is that correct?
Correct.
Okay. Are you aware of any other instances where Alex Cox engaged in conduct towards other people with the use of any kind of a weapon?
Of a firearm?
Any kind of a weapon.
I know that there was an incident with Lori's.
Objection, Your Honor. May we approach?
Yes. right, thank you, counsel. We took up a evidentiary ruling outside the presence of the jurors. Mr. Pryor, you may continue with your cross-examination.
So we talked a little bit about the fact that you're aware that Alex visited the gun range in September of 2019, right?
Yes.
You're not aware of whether he had visited or went to any gun ranges when he was living in Arizona 6 months prior. You didn't look into that. Is that right?
That's correct.
Okay. Now, officer, on your, this will be tricky. On your Homer J. Maximus, you talked about a number of searches. That, didn't you recall that, correct?
Yes.
Oops, Judge, this is the Elmo. I'm sorry.
And what is it you're publishing?
Uh,
Okay. This is part of Exhibit 107B.
And this talked a little bit about the gun and the distance and everything else, correct?
Yes.
And what I'm wondering about is that the first one that says the Grendel drop 100 to 200 yards, correct?
Yes.
Okay, now Tammy Daybell's driveway, and you described it as the distance between the end of the desk there and towards this first section here, correct?
Yes.
And for a clear record, we're 30 to 40 feet?
Sure.
Okay. Now, if we do math and look at 100 yards, how many feet is 100 yards? Do you know?
Well, there's.
I can help if you'd
Yeah.
like.
Yeah. Help me out.
Yeah, me too. I had to look at, no, I didn't have to look it up. It's 3 feet per yard.
Correct.
Okay, I'm sorry, and I know you weren't, that's not fair. It's 3 feet per yard. Okay, you
Yes.
know that, right? So if we're looking at a Grendel drop, we start at 300 feet, right?
Okay.
And then if we go to 200 yards, we go to 600 feet. Would that be fair?
Yes.
Now, none of those feet distances really apply to Tammy Daybell's driveway, right?
Not her driveway.
Okay. And then the 100 yards to 300 yards is the same thing, 300 feet to 900 feet, correct?
Yes.
So obviously what he was looking at this point is the distance on how to put a rifle and the amount of drop after you shoot it, that the bullet drops after a certain distance, right?
Yes.
And when was this in October?
This was searched October 8th.
Okay. And, you know, when I looked at this, I was curious, is there any indication that Alex Cox purchased a big game hunting license in October?
That I am unaware of.
Okay. And would you agree with me that October is also hunting season for various big game?
It is hunting season, yes.
Okay. And then he looked at, and you could use a Grendel for a hunting gun. Is that correct?
You could, yes.
Yeah. Okay. And if you were to purchase pants and just trying to just conceal yourself while you were out hunting, it wouldn't be inappropriate to buy different various suits to conceal yourself. Would you agree with that?
Yes.
Okay. Oops. I'm grateful to whoever put the tape up there. And then we go to October 10th. How to prepare your AR for cold weather. Now, if you're out shooting and you're out hunting, and I'm not suggesting we use an AR for hunting, but in October when you're out hunting, that's a cold time to go hunting, isn't it?
Yes, it could be cold.
Okay. Okay. And then we talked a little bit about the ghillie suit, and potentially that could be something that could be used as a hunting outfit when you were out in the game hunting, right?
Could be, yes.
Yeah. Well, you can buy those at Sportsman's Warehouse or Cabela's or any of those stores, right?
Yes.
You looked into that, and that's where you get them, right?
You can, yes.
Yeah, Sportsman stores for outdoor activities in October, right? Right?
Yes, you can buy them there.
Okay. Now, what we did is then we looked at a FBI simulation of shooting a 5.56 through car doors and walls. And a 5.56 is a type of a bullet, right?
Yes.
Okay. And that's a specific bullet. And what it appears is there was a search to see what kind of a bullet would go through car doors and walls, correct?
Yes.
And then you would also see what kind of caliber under that would penetrate a windshield, correct?
Yes.
Now we know that the allegations about Alex Cox is that he took a shot at Brandon Boudreaux, correct?
Yes.
And in relation to Lori Vallow, Brandon Boudreaux was Lori Vallow's, no, Melanie Pulowski was Lori Vallow's niece, right?
Yes.
And she was married to Brandon Boudreaux.
Yes.
So Brandon Boudreaux was the male spouse of Alex Cox's niece, Melanie Pulowski, right? Correct?
Yes.
Okay. So Alex Cox took a shot at the male member of the relationship between Melanie, Lori's family, and the male, right?
Yes.
And then Alex Cox murdered husband number 4 by taking a gun and shooting him at close range. And that was Lori Vallow's husband number 4, correct?
I'm not sure what husband it was.
Okay. Well, she's had
But-
5, right?
Okay.
Well, do you know that?
I'm not 100% sure on how.
Oh, that's okay. That's okay. Okay. So, but we do know that Alex Cox is accused of murdering Charles Vallow, correct?
Yes.
Okay. Now, when I go down, you testified that Chad Daybell, well, before we get that, it would seem that, would you agree with me that it would seem that the searches here, the Google searches, would suggest that Alex Cox is looking at shooting at some sort of a Dodge Dakota vehicle. Would you agree with me?
Yes.
And it looks like it wasn't for target practice. It was to do some harm, correct?
I don't know what his intent was, but it's not target practice, I would
Right.
say.
Well, it wouldn't be target practice if you're trying to penetrate a windshield, is it?
No.
And it isn't target practice if you're asking how thick is the 22 gauge steel on a Dodge Dakota, right?
No.
So apparently, what Alex Cox had in mind was to do some harm for whoever is driving a Dodge Dakota, correct?
Yes.
Are you aware that Chad Daybell was the one driving the Dodge Dakota?
Objection, Your Honor. Facts not in evidence.
Abstain.
Are you aware of the 2 vehicles that Chad and Tammy Daybell owned?
I'm aware of a Dodge Dakota that was registered to both of them.
Right. But you don't have any specific information about whether or not it was Chad who was the primary driver of the Dodge Dakota, right?
I don't have any facts that he was the primary driver, no.
Okay. Okay. Now, as part of your investigation, you talked a little bit about phone records, right? Phone records. Alex's records in terms of his location, right?
On Homer J. Maximus device.
Okay,
yes.
and you looked at that. What was the device that you were reviewing to determine that?
I'm not sure what device that was.
Okay, okay. All right, then we'll save that for another day. Now, Judge, previously, we stipulated and the court entered exhibit number 14. I'd like the court's permission to go over exhibit 14 with the witness.
All right. Has that previously been admitted?
Judge, I have it here with the stamp on it. I think we had already established
Yes, Your Honor. I think,
established and stipulated to it, Judge. I'm sorry.
and the state had reviewed this. It's my understanding these are the extracts from Tammy Daybell's phone or contain extracts. I think it's actually a police report referencing those extracts from her phone.
Okay. It's been admitted, so it may be published.
If I could just have a moment, Judge, I'm sorry. Judge, I'm ready when
Your Honor, I hate to do this, but can we briefly approach?
Yes. All right, counsel, before publishing that particular exhibit, we just redacted an identifier mark from that we caught. So you may go ahead and publish when you'd like, Mr. Pryor.
now, officer, on this particular document, I would represent to you that this is one of your reports. Do you, on the little bit that you're seeing, do you recognize that?
Yes.
So on March 16th, you received information from Google LERS. What's LERS?
Google Lears Law Enforcement.
Okay. and you asked for information attached to this, and this was information that you were getting regarding Tammy Daybell's email account. Would that be fair?
Yes.
Did you get the entire email account?
Yes.
And did you go through the entire email account?
Yes.
And you reviewed all of the emails and you made a determination as to which ones you in particular felt were relevant to this case. Is that right?
Yes.
Okay. And then you said after looking at the emails, you didn't include the ones that were significant. And there were photos, emails, chats, the information that I found relevant to the investigation, you see attached here, correct?
Yes.
Okay. And then would you read the line that starts in the email folder are chats? Would you read that one for me?
In the email folder are chats between Tammy and Mark while on his mission. Want me to read the whole?
If you would, if you don't mind.
There are also chats between Mark, Tammy, Seth, Garth, and Emma. During some chats, it is very clear that Chad is messaging. In the chats, it is also clear that chats are coming from Tammy's email.
Okay. And then I'll go to the next line saying, looking over the inbox of Tammy's email, it shows, oh gosh, I'm so sorry. Let me get a record, right? Looking over the inbox of Tammy's email, it shows the first section is chats, mainly with Mark, while he is on his mission. In the chats, it does not show the time or date when the chats are taking place, right?
Yes.
Okay. Then the line below, why don't you read the line below for me?
While looking over the chats, there are several that lead me to believe Tammy, along with Mark, Emma, Garth, Seth, and Leah, have knowledge of the belief in light and dark people that Chad talked about and believed.
Okay. So what I gather from that is your assessment in the reports that after you reviewed all of the emails and you said you reviewed them all.
Yes.
That's a significant job.
Yes.
And in reviewing all of those, you came to the conclusion that the Daybell, Tammy Daybell, Chad Daybell, and his 5 children had knowledge of the belief in light and dark people.
Yes.
And the light and dark is a religious reference that's mentioned by Chad, right?
Yes.
It's mentioned by other people in this case, right?
Yes.
It's also mentioned to some extent in predominantly most religions. Would you agree with that?
Say that again.
Predominantly in most religions, there's a reference to light and dark, right?
I can't testify that. 'Cause
Okay.
I don't know all the religions.
Okay. And then the religious practice that these folks practice, that Tammy and the children and Chad practices, of what faith?
LDS.
Okay. Okay. Then we go on and if you would, I'll take a look at the next one where it says during the chats, Mark's camera was not working and Tammy informed him that his camera was cursed and Dad was removing it, right?
Yes.
Okay. In more chats, Mark asked if anything was found or notable in him when he was body coded. I'm not sure what body coded means. Do you have any knowledge of what being a body or body coded talks about?
No.
Okay. Okay. But it was Mark who was talking about the body coding. Would that be your assessment?
Yes.
Okay. And then Tammy responds, you has a lot of weapons, negative chords and curses, plus trapped emotions. We cleared out quite a bit. We'll do that more regularly for you. So second to the last sentence says we cleared it out, right?
Yes.
That would you believe that was Tammy and Chad who were clearing out these negative chords and curses?
In this email, yes.
Okay. And then we'll do that more regularly for you. And again, we'll do that more regularly for you. That implies that it was both Tammy and Chad talking about helping them clear out these weapons, right?
Yes.
Okay. Then we go down to the next one, and it starts with on another chat. Chad said, Mom and I taught 12-year-old Sunday school yesterday. Canyon Scott's actions confirmed he is 4.2 dark. You see that?
Yes.
Do you have any knowledge as to whether Canyon Scott is dead or has been murdered or any investigation into that kind of a matter?
I have no knowledge of that.
Okay. And do you know who Canyon Scott is?
I do not.
Okay. But obviously, it's someone who attends church or attends Sunday school where Chad and Tammy went to their Sunday school, right?
Yes.
So we could presume that it was someone in Fremont or Madison County, right?
Yes.
Okay. And then it goes on, I will enjoy watching his growth to world terror and domination. And then Emma replies, I like Canyon though. I'll slow down. I'm sorry. I'm so sorry. The next line is, I will enjoy watching his growth to world terror and domination, right?
Yes.
Emma replies, I like Canyon though. Tammy and Chad reply, unfortunately, he's already influencing Will Dowling. Who's Will Dowling? Do you know?
I do not.
Okay. Then Mark goes, I like Jose, and I can't pronounce that last name, Ojeda also. Then Mark says, darkness is interesting. And then Tammy and Chad both say, maybe they're influencing you too. They are charming, right?
Yes.
So we don't have any information about Jose Ojeda or anything about him, any criminal activity associated to his demise, right?
Not that I'm aware of.
Okay. Judge, it's 12 o'clock. Judge, it's 12 o'clock. I don't know. This may take a while.
Sure.
It's up to the court.
Yeah, let's
obviously.
take our lunch recess. We try to do that at noon for timing of things, so that'll work out well. We are stopping right here about noon. We'll try to resume further testimony 1 o'clock and take the lunch break now.
And Judge, may I leave my stuff up here?
Yeah, we'll secure the courtroom and you can leave that there, Mr.
Thank you,
Pryor.
Your Honor.
All right, please.
To jury during opening statement. So I need to know what parties intend to put up for exhibits or for chalks, whatever you intend to put up in opening. And I know you're doing the opening, Ms. Giannetti, so I need to know what you intend to display.
Nothing.
Okay, that makes it easier. So while we're talking just briefly of openings, you had told me, Ms. Giannetti, that you thought you could get everything in 35 minutes. I will give you both 45 minutes.
Oh, that's perfect. Yes, I'll be less than 45.
I'll hold you to that.
I know you will.
All right, so Mr. Lally, 45 minutes for the Commonwealth?
Yeah, sure.
Okay. All right. And Commonwealth, do you intend to put anything up during openings?
During openings, no, Your Honor.
All right. Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
I don't recall that, Your Honor.
All right. Well, Commonwealth's entitled to a voir dire. There'll be a voir dire.
My understanding of the court's ruling, as it applies to opening statements, is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowden evidence.
As long as you know what's coming into evidence.
That's perfectly fair.
Remember, I use that term, competent evidence.
Of course.
That's what it has to be.
Of course.
All right. I'm sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319. So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So As you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
And, Your Honor, I think what I would suggest might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish and
We have a couple of motions where we do need to do that.
Right.
But for generally with this, and because this was broad, that's why I did want to, when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question-by-question basis. Does that work, Mr. Lally?
Yes, Your Honor.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay.
Commonwealth will object.
Commonwealth will object to specific questions.
Thank you.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay?
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion, eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experienced, and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means, but no, in terms just the common sense knowledge of common sense definition of what that is. To my knowledge, they're not going to be talking about any.
Okay, I think it's pretty clear what it is. But if you think they're not going to do it, if it seems that they are, then we need to know. And how about the scientific studies?
The scientific studies would not be referred to in any of their testimony that I'm going to elicit at all.
Okay.
They did some scientific studying of the material.
No, do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing to learned treatises that I'm going to elicit.
Okay. All right. That's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21. Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Binns, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment, Judge.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Binns/Qualls type testimony.
Right, so I think our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we call it that.
We had to without knowing the specifics.
So on the second page of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. That goes squarely with qualls and bins.
Right. With regard to the text messages, I don't believe we have a basis to object.
All right. So I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to...
What are they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
All right. Ms. Giannetti, I'll hear you on that.
Our expectation is any statements that were made, allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in. And you've had the benefit of the sane interviews for a long time.
Correct.
Right? So,
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
all right. So on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
Okay. All right, so sort of the same. 310. All right, and the defendant's is 283. It's a similar motion. So, Mr. Lally, why don't I hear you on this? So this is the one when I said there are 3 areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases with state of mind clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
So there's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that.
Okay.
What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship, or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, Your Honor.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness and the grand jury.
Okay.
In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports and the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective, as to the nature of their relationship. And then taking all of that sort of in conjunction with the text messages between the two that day and the voicemails messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people, whether they be troopers, whether it be paramedics, whether they be Ms. McCabe and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument essentially at the house at Fairview Road right before she had left. So those are sort of the totality of the sort of specific areas in the nature of the relationship that the Commonwealth would be seeking to explore through the testimony of a number of different witnesses.
Okay. Who's arguing this for the defense?
I will, Judge. As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, you know, it's difficult to, again, just give one blanket objection, one blanket assent to this. You know, generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the Bins line of cases. So
correct.
I did rule that those are coming in.
We recognize that,
okay.
Yes.
You said probably.
Well, yes. Well, Mr. Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you know, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. You know, I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it's, you know, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on not.
So no, so and okay, so that's well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah, so you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Kamala versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome proposed limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Bins line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So That's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82. And that's denied. I mean, it will not go to propensity, and we can make sure of that. And the Commonwealth's motion is 310, Jim, the bold 20, and that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion eliminate to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again, I read it every day for the last week.
That's okay. It's Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Your Honor, thank you. Since the last time we were in court, we've had an opportunity to look at that.
Yeah, I'd like to look at it, but okay, so you looked at it?
We did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears. It's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lally, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so, yes.
All right,
I'm
thank
speaking
you.
for.
Yeah. All right, so Jim, 306 is allowed?
Thank you.
All right, so the two that may take, there's three actually, but the two that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive, I would submit, as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a witness.
Why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lang being involved in some sort of altercation himself, in whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family, or even two, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment, particularly where it's an unsustained finding and there's nothing concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham, if it's admissible for other purposes, then it can come in. Right. Who's arguing this part? We'll take these in two parts, so we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those two cases, but if you want to, you can, but I'm more focused on the bias or motive part.
I'll just briefly address Graham and McFarland, because I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously...
Let's focus on Lank first.
Sure.
Okay. So, I agree with you. They're discovery cases. They're not admissibility cases.
Okay. So that issue aside, Lank has... he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court's attention.
The Albert family appears to be huge, right?
Well,
or very extended family.
Well, I'm getting there. So the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is...
Who would you intend to... If I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the LaPolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through, and how?
Through Sergeant Lank himself. I think we need to be afforded the ability to cross-examine him. Once that's done, we may need
if he denies it, and we'll figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have his testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our cross-examination.
Okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So go ahead. So through him, through Chris Albert?
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So I'm not going to take any action on this right now.
Okay.
But I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your Honor.
We'll see where we go with this, okay? All right, so now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked and a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay. How recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then it's, I would submit, inferentially inadmissible. So what I'm suggesting with this motion, or what I'm arguing in this motion, is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more, because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing, and to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists, without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is, or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth, it's unfair to the witness to be put in that position when there's really no information available.
All right, what do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there something in the, hold on, is it something in the information that you've received?
Yes, Your Honor.
From Mr. Lally?
Yes, Your Honor.
All right, so can I get a copy of that?
Yes, Your Honor.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So, regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no basis for it.
I didn't think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IED, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the District Attorney's Office in relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor?
We will call Trooper Proctor.
To impeach him?
Yes.
All right, so be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others?
Sometimes, but he is the primary investigator in this case. And I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Giannetti? Because I need more information.
I'm not going to mention the IA investigation in my opening statement.
All right, so Ms. Tallali, if you can get me that information that you mentioned that you had sent to counsel, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation, and if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right, so we need a little time. I need to read those materials.
Sure. And for the court's edification, I don't anticipate he's sort of towards the middle, I would say.
Okay. All right, good. And the more fully the record's developed and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So, all right. So not in your openings on either one of these, Ms. Giannetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. we'll see how the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation.
Judge, that's paper 339.
All right, and the Commonwealth, I mean, the defendant's is 289. It's the addressing the same issues. Yeah, I told the Commonwealth to put this in writing. So I guess it's defendant's motion. So I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is at issue.
All right, can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the blood was drawn,
yes,
all of that?
Commonwealth would have the doctor that ordered the blood draw, the nurse / nurse practitioner, I summons both, as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center.
Okay.
What I hope to...
So let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the motion, but does that change anything, Mr. Jackson?
It doesn't, because the individuals that did the blood draw, it wasn't done in an accredited manner. I'm not arguing with the fact that the blood draw was taken, that somebody with a phlebotomist actually took the blood, but it wasn't done with the protocols or the accreditation that's required under Massachusetts state law and the Massachusetts State Police Crime Lab. Their protocols were, I apologize, their protocols were breached internally, and given that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited and a foundationally solid blood draw to begin with.
So if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view, they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore it's overly prejudicial.
Okay. Mr. Lally, doesn't this happen in hospitals across Massachusetts on a regular basis?
It does, and just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital, and what the technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures because they're not the ones who actually conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's recollection. I mentioned this at the last hearing, but just one element of the problem is in the result. The extrapolated result was 124% swing In other words, we extrapolated based on the blood draw.
Yeah, I know what it means.
And that's just massive. I've never seen a swing that big. It's, you know, you pull somebody over. Well, they
Sounds like a great area for cross-examination.
I think it will be.
Okay.
But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
Yeah. I don't see how this doesn't come in.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury, and we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can cross-examine, but I don't think that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why don't we wait, and if need be, we'll have the experts. Let's wait until it gets closer to these experts or the folks from the hospital testifying. If we need to have a short voir dire, you need to remind me to do that, Mr. Jackson, okay?
Well, thank you for that, Your Honor. Appreciate it.
All right. Okay, so the last area I have is sort of logistics and sequestration. So so the Commonwealth filed a motion initially. You know what, we'll hold off on the logistics regarding the audiovisual assistant. So there was a motion in limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew, can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, well, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list. He is exempt also by me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it, so there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from a prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify to and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impanelment was with reference to the district attorney testifying as to whatever issues, purported issues of conflict or removal of Canton Police Department from the investigation. Certainly those are questions, I think, far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself. Secondly, with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family. I know there was a lot of discussion about this in grand jury minutes that I read about scheduling appointments, meeting with people, things of that nature.
So, I mean, what to say assist, I think is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates, is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses, in preparation of grand jury, in preparation of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses governed by a professional relationship? Is he somebody that they are able to call? There's been a lot of allegations of harassment of witnesses.
Correct.
Are those folks able to call him when something like that happens?
That is the person that they would call.
Okay.
Yes. So I think the bulk of the communications, the conversations with witnesses who are not members of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right, who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out D.A. Morrissey and victim witness advocate Steve Nelson in
okay.
this argument.
Let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged victims.
So when you were a prosecutor, you worked very closely with victim witness advocates.
I did.
Okay.
Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue. And that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the testimony. I don't think he said destroy.
I used the disjunctive rather than the conjunctive because from memory, I can't remember the precise language, but it was conveyed to. I'm told that the precise language was to get rid of. Which, would be consistent with what I had
told
said.
He could get rid of, not told he must get rid of?
Correct. In other words, Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted. And yet he stepped into the case, gave authorization that he did not have to give for the disposal of a phone which is relevant.
Okay, is that the sole issue you want to?
Yes.
The sole issue?
Yes, that's with regard to Mr. Nelson. It's different with regard to Mr.
All right,
Morris.
what's the Commonwealth's response to that?
I don't believe any of that is accurate. So what counsel is referring to is there was a motion to preserve cell phones. The Commonwealth notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to, hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted, the Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied. I believe even from Mr. Higgins' testimony in the federal grand jury that counsel is referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as the question was, all of these issues were explored in that particular area, and just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
All right, so Ms. Giannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your Honor.
So here's what I'm going to do. Let's wait and see how Mr. Higgins testifies. Okay? I am not going to order sequestration of Mr. Nelson, and let's see how the testimony is, and if you need to call him, you let me know, and we'll have another hearing on it.
Okay, we'll do. And just to answer an anticipated question from the court, I do not open on this issue.
You cannot open on that issue, Ms. Giannetti. Do you still need the 45 minutes?
That takes away nothing from my opening.
All right, so Jim, I'll start writing. I'll write something on this.
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your Honor.
Yeah, I'd order it, but he's willing to do it.
Thank you.
All right, so I just need a minute to write this up.
Sure.
All right. So regarding DA Morrissey.
Yes, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue that is part of the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard. However, this case is different for two reasons. One is the conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in. The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you want to play that video?
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question DA Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified DA Morrissey at a very, very early juncture at 8:30 a.m. A phone call from Chief Berkowitz to DA Morrissey notified him that Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that DA Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton police were conflicted out. And then the problem is that the Canton police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under DA Morrissey's control, that, there were violations of that sort of conflict of interest taking Canton out of the case that DA Morrissey became aware of and that DA Morrissey did nothing about. And so in terms of, us being able to, attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with District Attorney Michael Morrissey. He was the one that was involved at a very early juncture on this precise issue of the conflict, and he became aware that that conflict was violated time and time and time again, and he did nothing. And I believe that that's ripe for cross-examination. With regard to his statement to the press, this may even be more compelling, not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotaped statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. That doesn't make any sense. It doesn't pass the straight face test. But those are his own words, and he made himself a witness by uttering those words, and he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He made himself a witness, and there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements, and also the fact that, you know, he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counsel is referring to as proper for cross-examination, they might be. But this would be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do, you know, as related to whatever.
As the law tells me I have to consider.
Correct. And so, you know, as it pertains to whatever extent the court allows as far as the Bowden defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those things in consideration, I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony.
140?
140.
Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
okay.
to.
Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another witness that could testify.
Yes, because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses, potentially, is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only two people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not seeking
I knew nothing about this.
Prohibit him from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time hearing any of that. All right. So it is a stretch. It is an uphill battle for you, Mr. Yannetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based on the testimony that comes in, and I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
Okay. All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
Great, thank you.
All right. So, when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having an a technology audio visual assistant at council table, but to use, it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single case in these courtrooms. And the Commonwealth shares their equipment Please tell me exactly what it is you want to do. And I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any... I know nothing about this, and I asked for information previously so I could have thought about it and, you know, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said put it in writing. Then we put it in writing.
But the first time it was brought up was after I had asked about logistics. Go ahead. Tell me exactly what it is you want to do.
Okay. So it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel. He can put monitors at the request of the court, put monitors on the bench, a monitor in front of the court reporter, a monitor in front of the Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us if I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination, and we say, okay, let's say we've got internal bait stamps that show photograph number 231, he'll know what photograph number 231 is. He'll have an outline that tracks our cross-examination or a direct examination.
So it will be only things that are in evidence or will be coming into evidence? You're not going to do that with disputed?
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. But no, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
All right, what's the Commonwealth's position on this?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know about the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the jury seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Ms. Giannetti, I'd like to finish first, and I'll give you the opportunity to speak to Mr. Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors, I don't want a monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request, so we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to I can't prepare with the Commonwealth's.
No, I understand that. I don't think he'll fit at counsel table.
I can't speak to that. I think he would. I think we could accommodate him. Or if he doesn't fit right at counsel table, we've also set up, he was on a relatively large case that we had in a small courtroom back in California, and he's set up just behind counsel table, and he's got his own laptop, and nobody else can see it, and he's got a type of screen that you can't see it from angles, so jurors are not going to be seeing anything, but I need to be able to, and Ms. Little and Mr. Giannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's the 4 monitors on the tables, 1 on the bench, 1 for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's again a tiny room at your request.
He uses very modest speakers that are appropriate for the space. So, for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear or the court can hear. In a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables. When it's my turn, switch, and now.
All right, so is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week ago. I mean, it's not a building that
I understand.
We can just last minute. It's a beautiful old historic building. We want to keep it that way. So. And
we will not mess anything up. As a matter of fact, I was told that by the Commonwealth that she uses switches, consistently. That's not new technology. It's very simple. It just allows both of us to be able to prepare with the audio-visual portion of the case more seamlessly. That's all. We just want to make it more seamless and more professional for the court and for the jurors.
So it would be during your case in chief?
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits during cross-examination?
I mean, unless it's an impeachment that I didn't see coming. But even in that case, my habit and practice, my custom and practice would be to approach, if it's a matter in controversy, or tell the Commonwealth in advance, I'm about to show this photograph. Do you have any issue with it? No, I don't. And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown seamless and more professional looking.
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again, this is, I don't have the time to do it, and I understand if you don't, but.
I think Ms. Gilman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here. So, but I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today? Thank you.
By the way, just Mr. Bates's defense, yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from this court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just didn't want there to be a sort of a hanging Chad where that's concerned. He didn't leave.
Well, especially where he didn't start out well, right? Being at counsel table during impanelment.
I understand that, and he's been told that was inappropriate and obviously would never happen again.
All right, so some sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects. Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object. That's it. And if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony you think is inadmissible. So those are pretty standard rules. I'd like to see counsel at sidebar regarding a jury issue.
Just a second.
tripped over something.
Okay, all right, fair enough. Thank you. And then lastly, from Tammy to Mark on April 28th, Dad is in Houston and won't be back until Monday night. So you'll just have to get to talk to me tomorrow. And what's the significance of that?
So on this one, this correlates with some of our other records showing that Chad was in Houston, and that Tammy was home alone.
Okay. Next one was something about, oops. And I don't see. Something that identifies the date, but it was something about a zone conference. Do you know what that was about?
I am not sure on that.
Okay. And then does it seem like your tapeworm medicine worked? Who's talking to who there? Do you know?
I would believe Tammy is emailing and talking with Mark on this one.
Okay. So it's Tammy who's suggesting that there was some tapeworm incident. She was having some sort of malady.
Correct. This might be a continuation of the page before.
Okay.
Possibly.
Okay. And the page before would have been this malady with the tapeworm would have been on the 28th of 2019. Would that be fair?
Correct. Yes.
Thank you for clearing that up. Okay. And then she goes on, I guess I should ask you, is that Tammy who said, I haven't slept well since Dad has been gone. I'm hoping to sleep well tonight.
Yes.
Okay. Okay. Then we're going to June 30th of 2019. Is that right?
Yes.
And then let me read this and then I'll talk to you a little bit about that. Another adventure we had this week involves a raccoon. Last year we had skunks. This year a raccoon. We thought stray cats were getting into the cat food, but nope. Garth saw it one night and it was a raccoon. We borrowed a little trap from Matt Price, but when Garth went out to check it that night, the raccoon ran up the tree by the trap. It was huge. No way it was going to fit in the trap. It was larger than Chase and had really long teeth. Garth kept his flashlight on it and called us in the house. Dad got his gun. He shot it out of the tree, then shot it again as it tried to run across the yard. We now have a raccoon buried in the compost heap. Something else got into a cat food a couple of nights ago, so we borrowed a larger trap from Matt. We didn't catch anything last night, so we'll see if we get anything tonight. If we do catch anything, Matt asked us not to shoot it because he has a friend who will use whatever we catch to train dogs. Joel I think that's Nickel, told me they've got a couple of raccoons and skunks they've been trying to trap, and some coyotes have been eating chickens at houses over by Jordan Graham's house. In all, it's been a crazy year with wildlife. Do you see that?
Yes.
And could you identify the date when they're having this crazy year with wildlife?
June 30th, 2019.
Okay, and the allegation with Chad Daybell is that there was an email that the prosecutor has alleged may have a different meaning, but that was September 30th of 2019, correct? September of 2019, I'm sorry.
I guess I'm unaware of what email you're referring to.
Well, would it be fair that the allegations are that they discovered JJ and Tylee's body and that they are presuming as part of your investigation that they were buried in Mr. Daybell's property in September of 2019?
Yes.
Okay. And there was some email by Chad Daybell that made mention of a raccoon. You recall that?
Objection, Your Honor, misstates the evidence.
Abstain.
Okay. So from what I gather, the allegations about the children being buried on Chad Daybell's property was the same year as this email as well, correct?
Yes.
And we're on June 30th of 2019. And the allegations against Mr. Daybell relate to around September, sometime in September of 2019, correct?
Yes.
So 2.5, 3 months later, there's at least 2 references about raccoons. Would that be fair?
Yes.
Okay. And there's a reference that they buried this raccoon in a compost heap. Where's the compost heap on Mr. Daybell's property? Do you know?
I'm not sure about
Okay.
that.
All right. And then we go on to July 7th of 2019, right?
Yes.
Here is the second raccoon. The first one was shot. Garth said this one is smaller than the first one. I like how the kittens are looking at him too. Okay, and that's from March 7th. And that's also relating to this raccoon issue. Would that be fair?
Yes.
Okay. And then we have a picture. Dad has lost a lot of weight. He just doesn't seem to eat much anymore, and he is exercising. You see that, right?
Yes.
But above that is a trap. Can you explain? Does that look like a trap?
Yes.
And somewhere in the back top of the picture, it looks like there's some sort of raccoon in it. Is that what you see?
That's what I'm trying to see. I
Okay.
see the kittens there.
I do. Okay. And the previous motions made mention of Tammy saying, here's a picture of the second raccoon. It's a smaller one. So
Would you like me to point it out?
you did find it? Go ahead if you.
So it's kind of hard to tell. The raccoon is right there.
Okay. Is that raccoon in the trap?
I believe so.
Okay. Okay. Then we go down and we have a picture of Chad and Tammy, right?
Yes.
And again, not the full email, but your perception is that there's nothing there that was relevant to this investigation, right?
Yes.
Okay. And then does that appear to be the side of the house?
Appears to be the back of the house, I believe.
Okay. And from the email, that would be a picture of July 7th of 2019.
I'd have to look at the first page. Yes.
Okay, thank you. August 4th of 2019. Dad is in Arizona. He's speaking to a small group on Sunday night and at a girls' camp on Monday night. He flies home on Tuesday, right?
Yes.
And that had reference to the August 4th meeting with Melanie Gibb and Lori Vallow and all of the ladies who met Sunday at a girls' meeting at Lori Vallow's house. Is that what that was about?
Yes, I believe so.
Okay. Okay. But that's not the full email. But again, you determined there wasn't any relevance to anything else. Would that be fair?
Yes.
Okay. Thank you. Okay. And we go on again. And we talk about from Tammy to Mark, again, Tammy Daybell to Mark on September 15th of 2019, right?
Yes.
And this was about a month before Tammy passed away. Would that be fair?
Close to, yes.
Okay. And she says, this was taken on Saturday. Joe planted potatoes in his garden. I had been sick in bed all day with a really bad cold, but I put on a hat and went over to pose for this picture, so it looks like I'm really a real Idahoan. But I went right back to bed after we took it. I'm still sick today, and my nose won't stop running. I will go to work tomorrow, though, because I am helping with testing, and getting sub work would be more trouble than it was worth, right?
Yes.
Okay. And then there's some mention of continue whining. I burned my arm today when taking some rolls out of the oven, right?
Yes.
And the relevance of this is that it was just mentioning that 3 weeks before 3 weeks before Tammy passed away, she was sick for one day and basically was sick the entire next day and just got up and made herself put on a good face and made herself and go back to work, right?
Yeah.
Objection, Your Honor. Counsel's testifying. I don't hear a question there.
Abstain.
She wasn't feeling well that day, right?
Correct.
It appears that she was sick the following day, right?
Yes.
She spent a significant amount of time in bed,
Yes.
and she put on the courage to go to work on Monday, correct?
Yes.
Okay. And then the one, your mom came to visit us Friday night and Saturday morning. Under orders from Grandma Cooper, I'll let her tell the story. What's the relevance of that?
So the relevance to that is from Ron Douglas to Mark, which
Okay.
Ron Douglas is Mark's grandpa.
Okay.
Through our investigation, Tammy did not drive very far alone. And so it was important enough for Ron, the grandpa, to email Mark and say, hey, your mom came to visit us, which they live in Utah, which is 3.5 hours away. And she drove all by herself.
Okay. And this was October 6th of 2019, right?
Correct.
And you were aware that the reason Tammy Daybell didn't drive by herself is because of some medical concerns about her balance and
Objection, Your Honor. Counsel's testifying. Facts not in evidence. Move to strike.
Abstain.
Are you aware that the reason Tammy Daybell didn't drive is because of some medical concerns she had for herself?
No, I am not.
Okay. I went down to Springfield by myself, October 6th. I drove there by myself and then drove home by myself. I'm a big girl now. I can tell you more about this in a bit, right?
Yes.
So by your indications, you're suggesting on October 6th, 13 days before her death, 12 days before her death, that she was able to drive. Is that what this is about?
That's what she's emailing Mark, yes.
And was there any indication that prior to that time she didn't drive or that she was concerned about driving?
Long distances, yes.
Yeah. Okay. Thank you. Okay. And this again touches on, I think we talked about this previously about the Wednesday during the day with Reagan Price and the person who took her dog. And that leads into what we originally started with. Would that be fair?
Yes.
Okay. Okay. And then there's one final email that talks about Matt Price sending audiobooks for Tammy to listen to, right?
Yes.
And that was for her trip?
Tammy sent those, I believe, to Matt Price with codes to get into the audio book.
That's right. I'm sorry. You're right. Okay. Thank you. And if I could just have a minute, Judge, thank you.
You may.
One last area. On the day that you got the call about Tammy's death, you received a call from who again? I'm sorry.
I missed a call from Deputy Greenhalgh.
Okay. But then you said something about you followed up with it later and did have a discussion, or my notes not accurately reflecting?
So I missed that call and called her back about an hour and a half later.
Okay.
And spoke with her on that, yes.
And then she recited the facts about what she observed. Is that right?
She informed me that she was on an unattended death. I went through and asked her if there's anything out of the ordinary, anything suspicious, and she told me there was not.
Okay, so according to Officer Greenell, there was nothing suspicious. Is that right?
That's what she told me, yes.
Okay. And then according to, did you have a chance to look at Brenda Dye's report as a result of this investigation?
Not the AG's report, no.
I'm not talking the AG's report. I'm talking about Brenda Dye's diagram and report about this unattended death.
I did not.
Okay. So from your perspective, when Officer Greenell contacted you and advised that there was nothing suspicious about the death, at that point, it did not require you to take any further action. Would that be fair?
Correct.
Okay. Okay. Thank you. Judge, that's all I have. Thank you very much.
All right, thank you.
Oh, you're right. Oh, my goodness. Okay, thank you. Wouldn't be able to make it without you.
All right, redirect.
Thank you, Your Honor. We're gonna, I'm gonna start a little backwards here and start with that last exhibit. You were shown some emails that you reviewed in the last exhibit by defense counsel. And there was some indication in there about people being light and dark. Do you recall that?
Yes.
Through your investigation, did you learn who it was that would label people as light or dark?
Chad Daybell.
You were also shown an email about Chad needing to do some work on Mark's camera. Do you recall that?
Yes.
And the indication was Chad was the one that had to do that work, correct?
Yes.
And I think specifically it referenced the camera was cursed.
Yes.
Mark wasn't at the Daybell residence. Is that correct?
That's correct.
Mark was on his mission?
Yes.
It was brought up that Chad had labeled some 12-year-olds as dark. Do you recall that?
Yes.
You were asked if those kids are still alive to the best of your knowledge. Are they?
To the best of my knowledge, yes. I hope so.
Were those Lori's minor children?
No.
Were they obstacles to Chad and Lori being together?
No.
There was also an email on March 31st of 2019 where Tammy was talking about getting ready for a 5K. Do you recall that?
Yes.
Did that indicate to you that Tammy was active?
It's hard to say. Active. Working out, you do different things, right? And trying to stay in shape, you do different things. Some people may run to stay in shape. Some people may go lift weights to stay in shape. So that may just have been something different she wanted to try.
Did it indicate to you that Tammy had a desire to at least do something to be active?
Yes.
Then you were shown an email that Tammy sent to Mark on April 28th of 2019 about Chad being in Houston.
Yes.
And can you remind us what the significance of that was?
The significance with that was we have information that Chad had gone there with Lori, and her emailing Mark saying that Chad's in Houston just kind of confirmed that.
And later on in that same email, we see Tammy say, I haven't slept well since Dad has been gone. Do you recall that?
Yes.
So Tammy indicated she wasn't sleeping well, and Chad was in Houston with Lori.
Yes.
Then the next one, there's a couple texts about a raccoon. Do you recall, or not texts, excuse me, a couple emails about a raccoon?
Yes.
And the first one is on June 30th of 2019, correct?
Yes.
And in that one, there's mention of having a flashlight.
Yes.
Did it appear that the raccoon was shot at night?
Yes.
Then we see another email on July 7th of 2019 with an image of a raccoon in a trap, correct?
Yes.
Do you recall ever seeing an email from Tammy to Mark about a raccoon in September of 2019?
I did not.
So Tammy emailed Mark twice about seeing a raccoon, but no messages in September of 2019 to Mark that you recall.
Not on this email, no.
Then you were asked about the message from Tammy to Mark on August 4th of 2019 about Chad being in Arizona. Do you recall that?
Yes.
And in the message, Tammy indicates that Chad is at a girls' camp.
Yes.
Was he at a girls' camp?
He was at a conference, I believe, at Melanie's or correction, Lori's house.
So again, he was with Lori on August 4th of 2019.
Yes.
Do you recall when Charles Vallow was killed?
July 11th, 2019.
There was an email also shown that was from Tammy to Mark on September 15th of 2019, where Tammy references having a cold. Do you recall that?
Yes.
And Tammy indicated she was in bed for a few days.
Yes.
And that was in September.
Yes.
Any similar email message to Mark in October about Tammy being sick?
No.
Then you're asked about some messages on October 6th, one from Ron Douglas to Mark and one from Tammy to Mark about Tammy visiting Springville, Utah. Do you recall those?
Yes.
Through your investigation, did you learn anything about Tammy having a medical concern that kept her from driving?
No.
Through your investigation, did you learn who encouraged her to go to Springville that weekend?
Yes.
And who was that?
Chad Daybell.
And circling back, Detective, do you recall the email, you've been shown it by both myself and defense counsel, that was from Tammy to Mark about the attempted shooting?
Yes.
And you were asked some questions about Regan Price and Tammy mentioning some things Regan had shared with her about a lady trying to steal Regan's dog. Do you recall that?
Yes.
Regan described a lady trying to steal her dog, correct?
Yes.
Did Regan ever mention the lady having a firearm?
No.
Did Regan ever mention the lady being dressed all in black?
No.
You were asked quite a bit about the Daybell's driveway. How many driveways are at the Daybell residence?
2.
And you were asked about a longer driveway. Would you consider that the front or back driveway or side driveway?
The back driveway is a very longer driveway compared to the front driveway.
And Your Honor, I'm going to ask to be handed States Exhibit 291.
Very well.
And Your Honor, may I publish?
You may.
And we've looked at this exhibit a couple times, but in that second paragraph, can you see which driveway Tammy came into that day?
She backed into the front driveway.
Is the front driveway that long?
It's, like I discussed earlier, about 2 car lengths.
And then is there a driveway that's even longer than that?
Yes.
And how long is the other driveway car lengths, if you could estimate?
Probably about 4 or 5.
So quite a bit longer.
Yes.
And again, were you part of the initial investigation on October 9th of 2019?
I was not.
And again, in that message, put it back up. In that second paragraph, do you see an indication of what time of day this occurred?
9:15.
And that would be referring to PM.
Yes, that's when the call came in around that time.
And again, you're from the Fremont County area, correct?
Yes.
And October's in Fremont County about 9 p.m. Is it still light out generally?
It's usually getting about dusk.
Do you recall reviewing? Let me back up. Would it surprise you to learn that there was no report by Deputy Cannon where he referenced having searched for paintball guns with Tammy Daybell?
Would it surprise me that there was no search with that?
That there was no Google search done for paintball guns?
Overruled.
No.
If Deputy Cannon had indicated that he never searched for paintball guns with Tammy Daybell, would you have any reason to dispute that?
No.
I think we talked about this a little bit earlier, but do you know how familiar Tammy Daybell was with firearms?
I do not know how familiar she was with them.
And counsel talked about some searches that were done by an email associated with Tammy Daybell regarding a paintball gun and an airsoft gun. Do you recall those?
Yes.
From your review of the October 9th investigation, did Tammy Daybell ever produce any photo saying this is the firearm?
No, she did not.
And yet she didn't do any search for a rifle, did she, that you're aware of?
No.
Are there various type of paintball guns in your experience?
Yes.
Your Honor, I'm going to ask to have the witness shown State's Exhibit 282.
Judge, I believe this is the image that we stipulated to counsel. Is that correct?
It is, Your Honor, and I do have a courtesy copy for defense counsel that's now been marked, a courtesy copy for Your Honor and a copy for the court.
All right, thank you, counsel.
Thank you.
And Detective, have you seen this image before?
Yes.
And that top image there, is that the Grendel 6.5 that we've earlier referenced?
Yes, it is.
And Your Honor, I would move for the admission of State's Exhibit 282.
Again, Judge, that was by stipulation of the parties, so
All
I
right.
am not having an objection to it.
Very well. Without objection, Exhibit 282 is admitted.
And Your Honor, I would ask permission to publish.
You may.
And Detective Counsel showed you an image of one type of paintball gun. Do you recall that?
Yes.
And that is just one type?
Yes.
And you'd indicated that they make paintball guns that look similar to an assault rifle?
Yes.
And again, that top image is the firearm that was seized from an apartment associated with Alex Cox. Is that correct?
Yes.
And the bottom one, it's marked example. To be clear, this firearm was never located. Is that correct?
That is correct. This was not located.
Can you tell us what we're seeing in that bottom photo?
So this bottom photo right here is a Tipman paintball gun with the Tipman. Yeah. On the top is a hopper. On the back has a collapsible stock. And then your barrel.
Your Honor, the state would ask to publish State's Exhibit 281C that's already been admitted. If
You
I
may
could be
publish.
handed that. And Detective, this is a close-up, again, of the front part of that Grendel 6.5. Is that correct?
Yes.
And if the firearm was pointing at someone, this may be a vantage point that of what they see.
Yes.
And Detective, again, Alex was in the area of the Daybell residence earlier in the day on October 9th. Is that correct?
Yes.
And then he was also in the area about 2.6 miles away the night before Tammy was pronounced dead. Is that correct?
Yes.
Counsel talked to you about whooshing and popping sounds from paintball guns. If a gun misfires, will it make a sound?
It depends what kind of misfire or jam it may have.
Are there various sounds that could, would the sound of a AR be muffled or different if it had a silencer on it?
Yes.
Counsel talked to you about Tammy being pretty close to the gun. She describes the gunman as right behind her and she turns around and he's there, correct?
Correct.
And we talked earlier about some searches done on the Homer J. Maximus account about a drop.
Yes.
If you're sighting your gun, and correct me if I'm using the wrong language here, if you're sighting a gun or trying to adjust it to fire a certain distance, is that different if it's a short distance versus a long distance?
Yes.
So if you'd been further away and moved closer, would it be sighted indifferent?
Yes. Could be.
And counsel talked to you about the bipolar teenager mentioned in the email from Tammy to Mark, correct?
Yes.
Again, from your review of October 9th, were there any reports of a bipolar teenager pointing a paintball gun at anyone?
No, not that I'm aware of.
Any reports of someone other than Tammy Daybell? Any reports of anyone else coming face to face with a masked gunman?
No, not that I'm aware of.
And do you, trying to make sure I'm referencing the correct exhibit. And Your Honor, may I have State's Exhibit 291 again, please?
Yes.
And may I also have Defense Exhibit 16? Yes, it is State's Exhibit 291 and Defense Exhibit 16. And I guess while I'm at it, I forget the exhibit number, but the second call into dispatch by Tammy Daybell.
$32B.
232B, Your Honor. And Your Honor, may I have permission to publish Defense Exhibit 16?
Yes.
Your Honor, defense screen just went blank. Oh, sorry, it popped up.
HDM Night does not like my computer.
Judge, if the court would prefer to take a short break now and we could do the early afternoon break.
Well, I think we'll get this sorted out pretty quickly here.
Detective, can I have you look at that first sentence there? And can you read it into the record?
Something really weird just happened, and I want you to know so you can watch out.
Tammy's sending this message out, telling people she wants them to watch out, correct?
Yes.
And Judge, I would now ask to be able to display State's Exhibit 291.
You may.
And at the end of that first big paragraph, do you see where Tammy indicates the scared part came after when my brain thought of other things that could have happened?
Yes.
And on this one, do you see at the end of that full paragraph where she says, I didn't go to Zumba because I quite understandably did not want to be out after dark alone?
Yes.
Do those statements indicate someone that was scared by what just happened?
Yes.
And in this one, do you see in that first paragraph where it says the guy started pulling the trigger and I could just hear the clicking and whooshing sound of an empty paintball gun?
Yes.
He was standing by the back of the car, just pulling the trigger while pointing the gun at me. Do you see that?
Yes.
Does this indicate more than someone just pointing a gun at someone?
Yes, it does.
Do you recall in the dispatch call with Tammy where she talks about the man pointing the gun at her and just shooting? And we can listen to it again. Would that be helpful?
Yeah, I don't recall that.
And Your Honor, may I publish State's Exhibit 232B?
Yes.
49 minutes, 20 seconds.
It's pretty much County Sheriff's Office.
Hi, I need to report something.
Okay, go ahead. What's the address?
Okay, at 202 North, 1900 East, the corner with the blinking yellow light on Salem Highway.
Is it a suspicious person?
Yes.
Okay, what was he wearing?
He was all dressed in black and he had a ski mask on.
And he said the blinking light now is where you saw him?
No, he's gone now because I pulled up into our driveway and I was getting stuff out of the back seat of my car and suddenly he was there and he had a paintball gun and he was and he was going to shoot at me. And I kept asking him what he was doing because I could tell it was a paintball thing. And then he just kept doing it. So I yelled for my husband and then he took off running around the back of my house.
Okay, give me just 1 minute. Stay on the line with me.
Okay.
October 9, 2019. 21 hours, 50 minutes, 28 seconds.
And that was North 1900 East?
Yes.
Okay.
October 9, 2019. 21 hours, 50 minutes, 43 seconds.
Do you know what direction he was going?
He went behind my house and it's so dark out there and I went in the house and got my husband and son and then they went out and looked and he was long gone by then. So he was on the north side of my house is where he went to get away.
Okay.
He didn't say anything or he just kept like he was holding the gun like he was, had a rifle and was shooting at me. So, but nothing came out of the gun either. So I don't think it was loaded.
Okay. What is your name?
My name is Tammy Daybell.
I'm going to stop it right there. Did you hear on there where she says holding the gun like he had a rifle and shooting at me, but nothing came out?
Yes, I did.
Does that indicate more than someone just pointing a gun?
Yes, it does.
Council talked to you a little bit about some of those searches associated with Homer J. Maximus. Do you recall that?
Yes.
About October being hunting season.
Yes.
Would shooting through a windshield or shooting through a Dodge Dakota generally have anything to do with hunting?
No.
Through the investigation, did you become aware that Chad had deemed Alex to be Lori's protector?
Yes, I did.
After Alex shot Charles on July 11th of 2019, did Chad and Lori maintain a relationship to? And I think you referenced it. Chad was down there on August 4th, 2019, just maybe about 3 weeks after Charles was shot and killed by Alex Cox.
Yes, he was.
Would that lead you to believe that Chad was scared of Alex Cox?
No.
Lead you to believe Chad was scared of Lori Vallow?
No.
Are you aware of any report taken by Fremont County where Chad Daybell reported that he was scared of anyone?
No, I am not aware.
Are you aware of Chad ever reporting anyone tried to shoot at him?
No.
And again, through the investigation, what was the connection between Alex Cox and Tammy Daybell?
Chad Daybell.
I have no further questions.
All right. Thank you, Ms. Blake.
Judge, I would like an opportunity to clarify the driveway, and then counsel went on about the relationship between Alex and Chad Daybell, and I'd like an opportunity to at least touch on that.
I'll allow some limited recross on those two issues,
Judge.
Mr. Pryor.
Officer counsel put up the Facebook posting by Tammy Daybell, and it describes the front driveway. Do you recall that?
The Facebook, I don't recall if that said the front driveway.
Judge, could I?
know in the email, sorry.
That's okay. I'm gonna have to have permission to go get my computer, Judge, and bring up that. May I have permission to go back and get my computer?
Yes.
Exhibit 16. Thank you. My turn now. I'm not ready yet, Judge. I think I'm ready now, Judge.
All right. You can publish that.
Okay, and I apologize. I can't get this to widen on me, Judge, but officer, can you read that if you look at your monitor?
Yes, I can, and it does say the front driveway.
Okay. And I'm sorry we had to go through that with all that time, but I wanted to make sure. And Judge, that's all I have for this.
Okay, thank you.
So there is no dispute that this was the front driveway, correct?
Correct.
And again, the front driveway is a very short driveway compared to the one in the back, correct?
Yes.
Okay, and further, the distance between the front of the house and where the car was backed up, that even shortens the distance even more, correct?
Yes.
And it would be unusual to use a rifle at such close range, correct?
Yes.
Yeah, that's not a weapon that you use at close range, correct?
Usually not.
Yeah. In fact, a rifle is typically used when we're talking about hunting. That's long range, which is consistent with Mr. Cox talking about 100 and 300-yard shots, right?
Sometimes.
And in your experience, if you're really trying to hurt somebody at close range, you would probably use a handgun or a shotgun, right?
Well, I guess I misstated right there.
Okay.
Rifles can be used at close range, close
Okay.
quarter combats,
Okay.
SWAT stuff. So
Okay.
yes, they can be used.
Okay. Now, the information you got about the Dodge Dakota, you recall that, right?
Yes.
And you talked about the fact that someone was talking about putting a bullet through the window of a Dodge Dakota.
Yes.
Someone trying to figure out what type of bullet it would take to pierce the side of a Dodge Dakota.
Yes.
someone who would take what kind of a bullet would pierce the metal or the thickness of the metal on a Dodge Dakota?
Yes.
So it would seem with Mr. Daybell owning a Dodge Dakota that it seems that at least the target was someone in the Daybell family. Would that be fair?
That'd be fair to say, yes.
Okay. And with the Homer J. Maximus account, is there any indication that Chad was shared all of the information on Alex Cox's Homer J. Maximus account?
Objection, Your Honor, calls for speculation.
Sustain.
Do you have any information to suggest that Mr. Daybell had access to the Homer J. Maximus account?
No, I do not.
Okay. So if Mr. Daybell didn't have access to the information in that account, do you have any other information that Mr. Daybell had knowledge that Alex Cox was looking for a way to shoot a Dodge Dakota that Mr. Daybell owned?
No.
Okay, nothing else, Judge. Thank you.
All right, that will conclude then the testimony of Detective Kaya Kamanu. And he's testified twice now. Is he still, well, he's the case agent, so I don't know if he'll be recalled or not, but Detective, you can go ahead and step down from the witness stand. We'll make sure to retrieve exhibits. I'll have a brief sidebar with counsel to discuss scheduling for today, and we'll take our afternoon recess at this time.
All rise, please.